Been before to the planning meeting here. There is outside to your left and then right some toilets. There's a table with some coffee teas. If at any point you feel you would like to have a drink, that is available out there for everyone. Now, over the weekend and today, all our communities have been remembering, and it was suggested to me tonight that just for a moment we stand and acknowledge the 11th of the 11th and all the servicemen and people who gave their best and their lives. Thank you. So I'd like to now formally commence the planning committee for the 11th of November 2025 here in the council chamber. And can I first ask, are there any apologies for absence that need to be recorded, please?
Thank you, Councillor. We've had apologies from Councillor Laura Melstrom and substitute is Councillor Neil Buttle.
So welcome to Neil. As a point of information, just in case any members of the public are present for the final application for Sycamore Road, that for the moment has been withdrawn and will surface at a future planning meeting. We wouldn't want anyone to be sat right to the bitter end thinking that was going to take place. So that will, as I say, be on a future agenda. Can I ask members now if they are prepared to approve the minutes of the previous meeting, that what there and therein took place was a true and correct record. Is someone prepared to move? Councillor Peter Slack has moved. It needs a seconder, please. Councillor Dobbs. All those in favour of the minutes that they be signed? And that is unanimous. Thank you, members. Are there any interests that members wish to declare? Councillor Peacock.
I have a personal interest in item 5.2 in that I'm friends with the co-owner of the property. I'll be sitting in the public gallery for that item.
Thank you, Councillor Peacock. Any other interests at all? No? And then, as the meeting proceeds, there are various contributions from members of the public pertaining applications. So if we move to section 5 of the planning agenda now, which is in fact applications for determination. So if members turn to pages 13 to 22 of your hard copy agenda or your electronic agenda, the first application tonight pertains what was, I think, our second site visit yesterday, Russett's 2B Wyston Road, Ashbourne. Now, there are a number of speakers. Sorry, no, there isn't for this one. So, can I then bring in the case officer at this point to outline the application, please?
There are speakers. Yeah, sorry, there are speakers. There are speakers.
Right, I do apologise. So first of all, can I invite Councillor Martin Spencer, who's representing Ashbourne Town Council. Martin, if you'd like to come to the desk, there is a microphone so everyone can hear. And you've got 3 minutes as and when you wish to start. This one there where it says speaker. So if everyone could bear that in mind, that this is where, please, come and make your presentations.
Good evening. On behalf of Ashbourne Town Council, our objection is as follows. Members feel that the scale and design of the proposed extension does not reflect the character and the property and surrounding area and would result in a significant negative impact in the neighbouring properties, specifically in terms of overshadowing, contrary to LP policy PD1 and HC10. Excuse me. Concerns regarding the removal of the garage would result in loss of parking spaces, which could potentially result in loss of off-street parking in a busy residential area. Thank you, and we hope you will take on board our objections when considering the application. Thank you once again.
Thank you very much, Martin. Is the applicant Tony? Is Tony Salaney? Right, sorry. Tony Salaney. Salaney is. Thank you, Tony. Would you like to come and express your comments, please, to the committee?
You've got 3 minutes.
Thank you.
My name is Tony Salini. I live in 2A Wyston Road, which is adjacent to that property. The property is going to overshadow my house and block some of the skyline, the only skyline I have, by removal of the garage and erecting a 2-storey building. More to the point, there was a similar application made not too long ago that was rejected and were taken all the way through the appeal process. And in the appeal process, the adjudicators decided that it was not fit to have a 2-storey or a 2-storey extension on any side of that property. The only place that was permitted was above the greenhouse. And then a few months later, exactly the same application, it's just things have swapped around and it's the similar size and similar kind of design. And it's not in keeping with the rest of the street. That's all, thank you.
Thank you very much, Tony. So I'll invite now Philip Marsh, please, local resident, and I think neighbour, yes. And Philip, you're going to speak against the application.
Good evening. The application totally ignores the appeal decision that rejected any 2-storey or part single-storey at the west end of the existing dwelling that is adjacent to the boundary of my property at number 12 Nuncombe Drive. The only acceptance by the inspectorate was a single-storey replacement for the conservatory on the east side, which is on Wyston Road. Despite minimal changes and additions, the proposed new plans of the revised 2-storey and single-storey extensions at the west end of the existing dwelling and the boundary with me at number 12, it still conflicts with policy HC10 and PD1 and causes unacceptable harm and living conditions to the occupants of us at number 12 Duncombe Drive. And that was described as by the inspectorate on the appeal paperwork that you have. I would also like to have a question for the case officer. The inspectorate would not allow any 2-storey part or single stories in its report and conflicted with policies HC10 and PD1 of the framework, and therefore planning should be refused on this basis. It also conflicts in its original design to match excuse me, 2A. There's a large amount of houses in developments in Ashbourne at the moment which are 5 beds, 4 beds. They're all large properties, and I can't see any reason why a large-scale extra development is needed when the smaller properties have better access for local people. The case officer's recommendations at the first application were actually rejected by a full majority of planning people, apart from one which didn't want to vote. It was then overruled by the appeal inspectorate because it didn't meet the local framework and has not followed guidelines from the appeal inspectorate against any two-storey extensions. So I was wondering why the case officer still continued to put it forward, recommending approval, when the inspectorate despicably denied that they should have any two-storey extensions or any extension onto my boundary, which is the new two-storey and the first-storey extension, which covers the whole width of my garden. I would just like to point out, I wouldn't have any extensions to a single-storey extension, basically keeping it to the original width of the house and not including the garage.
Unfortunately, Mr. Marsh, I have to interject. Yes.
Okay, thank you very much.
Thank you. Could Lisa Simpson, please, local resident, come and...
Do you mind if I start?
No, not at all.
Thank you for giving me the opportunity to speak. My name's Lisa Simpson. I live at 14 Duncombe Drive, adjacent to the property in question. Local estate agents state quite clearly that the Shires estate, of which we are part of, is a highly sought-after development in Ashbourne, a beautiful natural setting, mature, green, open spaces, which attracts families. There are examples on the Shires estate of single stories and of some double-storey properties, extensions, but not of the scale that we are looking at today. What makes this application different and difficult is the overdevelopment, 80% bigger than what is currently there, a design and scale out of character, resulting in a cramped development, overbearing visual dominance, a loss of amenity, diminishing the enjoyment of neighbouring properties both on the Shires estate and also on Wyeston Road, an adverse effect on residential amenity, and in direct contravention of policy that councils set for the benefit of local residents. This would set an undesirable benchmark precedent, of which can have detrimental effects in the future and significantly affect the fabric of the area. I too refer to the Planning Inspectorate report of January this year. It's available for you all to read, but I would refer you to the conclusion, which clearly states, I conclude that the two-storey and part one-storey extension element of the proposal conflicts with the development plan as a whole and with the provisions of the framework. I have no objection to a single-storey extension, but I do object to double-storey extension in contravention with the framework and in direct contravention with the inspector's report. I ask that you listen to the residents of Ashbourne and the residents of the locality to this property and do what is right tonight for us. And if our neighbours so wish to have single-storey extensions, so be it, and we would be in favour of working with them to achieve that. Thank you for your time. Thank you, Chair.
Thank you for your contribution, Lisa. So I call upon now the applicant, who has 5 minutes, and that is Colin Young.
Hello councillors, ladies and gentlemen. Thank you for the opportunity of presenting our planning application. It's the second attempt at planning to be obtained, as you've just heard, and it's been fully through the appeal procedure. Because it's been through the full appeal procedure, many of the material planning considerations have already been ruled on by the Planning Inspectorate. And it's clear from the Planning Inspectorate's report that they gave an indication that there was a way to do this in a more sensitive manner. And they did suggest in their report that we had to remove the bulk on the west side of the property towards Duncombe Drive. To achieve that, we've taken the second-storey property over the family room and moved it over the conservatory. In doing so, that has moved 46 cubic metres of property to the other side of the property. And we also, with what was left, made it smaller and have hip-roofed the bedroom so that that also is a smaller impact. We followed the instructions from the inspectorate to make it of the same materials as the existing house, so that that aspect has been dealt with. But many of the issues that the inspector highlighted, we followed. Now, having put our proposal together, we then came to the planning office and we went through the full pre-planning approval process, because we were very conscious that we didn't want to do anything that didn't meet your planning rules or regulations. So we went through that full process, and I thank the planning officers for coming to the house. We had 2 planning people come to the house, spent 2 hours with us, went through every aspect of it, and we amended our plans in line with their requests. As a result of that, we ended up with a planning proposal that you see today. Now, from my point of view, the planning officer has proposed approval. They're the expert, I'm not. Our architect and they have worked together to come up with a solution. Last time when we put it through, the planning officer part approved and part rejected. And when I read the report, it doesn't say you can't have a 2-storey extension on the west side. It just says it has to be reduced in bulk, which we have done. And that's why we took it to your planning officers in the pre-planning process, to ensure that we understood and followed every rule, national and local, to achieve a solution that was acceptable. Therefore, I would ask you to approve this and follow the advice of your experts. Thank you.
Thank you, Mr. Young. Let Mr. Young get back to his seat, and then we'll invite the case officer to outline the report before members. So, Gina, if you'd like to proceed, please.
Thank you, Chair. This application is for the Russets to be Wyston Road at Ashbourne. It follows a scheme that was previously submitted to the authority last year, went to committee, and it was refused by the committee. It was then taken to the inspectorate to dismissed it in part and allowed it in part. So they dismissed the extension that was the 2-storey element to the west, and they allowed a single-storey extension to the eastern side. Since that decision, the applicant has put forward a new scheme. So again, it's proposed single and 2-storey extensions and the removal of the garage. So this scheme was presented by the applicant agent following the previous appeal decision, which was dismissed in part. I consider the revised scheme as presented to me to address the reasons for refusal on the previous appeal decision, namely in respect to the massing of the extension to the western boundary and the potential overbearing impact. So that was something that the inspector did consider at the time under paragraph 16 of the decision, and it says, I find that the introduction of a 2-storey elevation of the scale and massing proposed by the side extension adjacent to the rear boundary of number 12 would result in an undue sense of overbearing. So it was to do with the nature, the massing of the 2-storey extension, rather than, I wouldn't read it as saying the principle of a 2-storey extension wouldn't be allowed, just that the massing needs to be revisited, which is what has been done on this scheme. So I wouldn't consider the comments rule out a 2-storey extension in principle if the overbearing impact of it could be addressed. Where the eaves of the 2-storey part of the extension formerly sat at 4 metres to the nearest part of the boundary, to the western neighbour, the revised scheme has set this back by 1.5 metres, so it's now 5.5 from the eaves of the 2nd storey to the boundary. So I think a lot of the massing issues, at least how they were presented by the inspector, I think have been given due regard in the amendment, and I think, you know, I wouldn't feel confident in taking forward that there wouldn't be a two-storey extension. It just needs to be appropriately massed. The District Council doesn't hold any design codes or policies in respect to capping percentage increase on extensions. Each case would be considered on its own merits, so the plot size, what's around it, various other things. I've included conditions in respect to ensuring an appropriate finish to the dwelling by asking for the render finish, and I've put a condition on to safeguard amenity to the neighbouring property to the west by removing permitted development rights for for any further windows to the extended part. I note the changes to the massing have resulted in new roof forms. However, I consider the building is fairly well concealed from the public realm, and the extensions are as well. So I think it would be, I don't think it would be significant enough where I'd want to make a recommendation or refusal because of the design. So yes, I consider the revised scheme as presented to me to address the reasons for refusal on the previous appeal decision, namely in respect to the massing of the extension to the western boundary and the potential overbearing impact. And I don't feel that, you know, that it is about the principle of the two-storey extension. It's about looking at the massing of it, which I think has been adequately looked at and reduced. But that's now put forward for the committee to look at. Thank you.
Thank you very much, Gina. Now we're going to proceed now into questions. Can I ask members please to kindly be concise and crisp, and to bear in mind that comments and views can be shared in the later debate. So first of all, Councillor Hughes, then Councillor Slack, and then Councillor Dobbs. Councillor Hughes.
Thank you, Chair. I think probably my questions are all about the west end of the development. And the first one is about the driveway. Now, the driveway needs to be extended to allow for parking of vehicles, 3 vehicles on site as required. And this is going to entail a retaining wall being built. The retaining wall will be against the I think it's number 12, to the west of the application site, and that wall, where the wall is at the moment, it will be put. There are currently trees that mask the building, that mask the applicant's building house from number 12. I'm concerned that the construction of the retaining wall will damage the roots of the hedge, effectively a hedge along that boundary, or will entail the removal of that hedge. Can you comment on that, Gina?
Obviously, I haven't been presented a retaining wall as part of this application. If there was one to be proposed, we would have to consider the impact on hedgerows, particularly, you know, if they needed protected, if they could be retained. Obviously, it would, if they're not protected by TPOs or in a conservation area, there is limited things, but we could still consider them as part of an application. So it would be, if it was presented a scheme for a retaining wall was presented, or alternative parking, then it would be something we need to consider at that time. But yes, at the moment I don't believe there's any protection on it, but we would seek to see, you know, if we can protect it if works were required close to those routes.
Can I come back? Thank you, Jean.
Absolutely.
At the meeting yesterday on site, we were told that there would be a retaining wall built by the applicant. Told us that there would be a retaining wall on the western boundary.
Yes.
And he pointed out where the western boundary was in terms of fence posts that showing the original fence.
Yeah.
Which were within his side of the hedge, but they were well within the hedge.
Yeah.
Now, I can't understand how he can build a drive without putting in a small retaining wall to stop the drive subsiding. There's a drop of about 60 centimetres or something down onto the level of the hedge.
Yeah.
And that would then mean that the trees would have to be removed.
If an application was made to create a retaining wall, that's something we'd have to consider. I did consult, I believe, the tree officer on this one, who didn't have any comments on it, so whether he didn't pick up on that. But if they're not protected trees, it would be something as whether we would, we would be able to support them being removed or not, or what if we seek to be them to be retained.
Okay, in that case, would the loss of trees result in an impact on the privacy of the neighbours' privacy, and would that be a material planning consideration?
Is that something we could consider? Sorry. Yeah. Sorry, Chris.
I'll take that, Chair, if that's okay. So it would be if that distance and that relationship was considered to be an unacceptable relationship without the tree present. So overlooking is clearly a material planning consideration. With regard to putting in place walls, fences and the like, they can be erected up to a height of 2 metres normally without planning permission, or 1 metre adjacent to a highway. So it may be that there is some work that is not included in the application because the applicant considers it to be permitted development. As I say, that it would be the application is what's in front of members today. It's not proposed as part of the application to carry out any tree work, and the council's arboricultural officer has commented on the application and not raised any objections. But in answer to your question about whether overlooking or loss of privacy is a material planning consideration, yes, it is.
Any further questions, David? You're okay. Councillor Slack and then Councillor Dobbs and Councillor Buttle.
Thank you, Chair, and thank you, Gina, for the presentation. Where the garage is at the moment, that'll be double extension. Will there be any windows facing the neighbour? Or I think somewhere there were windows planned, but that would be affecting the neighbour's privacy.
On the western side, there's a proposed doorway and a single window towards in the ground floor. No two roof lights, and there's no windows in the side elevation of the extension, and then some further roof lights within the two-storey element. So no side-facing windows other than on ground floor.
Which way will the roof lights face?
So the roof lights will be facing west, but obviously they will be in the pitch, with the pitch as well.
Yeah, my second question is, now the garage is going in the proposals, where 2 parking spaces will be gone, all that area of drive, does the occupant own all that, or is someone else can use that drive?
In the application, it's under Certificate A, which is to say it's in sole ownership, so that's our understanding of it. We take what's on the form presented to us, and I've not been told otherwise. So it is within his control as far as I am aware.
Right, thank you.
Thank you, Peter. Councillor Peter Dobbs.
Thank you, Chair. My first question concerns the comments of the Planning Inspectorate. Would it be fair comment to say that the Planning Inspector essentially agreed with the opinion of this council, this committee, when commenting on the previous application, and his comment about the single-storey rear extension was simply because that would be allowed under permitted development anyway?
Yes. Yes. Oh, sorry. Yes, I think it would. Yeah, the single storey to the other end previously was allowed, but like I say, it was permitted development, so it was just, I suppose they had to give it a decision. But yes, it was allowed because it would have been considered a permitted rear extension.
Thank you, Gina. We don't often get the chance to say that the inspector agreed with us, so I thought I'd just celebrate it. My second question concerns the nature proposed in this application of the extension at the place where the conservatory is at the moment, and that is now two stories, which is presumably how the comment from the applicant about the additional 46 cubic metres presumably comes from. It's not, in a sense, shifting something. It's being created by the extra floor, which wasn't there last time. Thank you.
Eastern side of it, yeah. The other end of it, yeah.
Councillor Butler.
Thank you, Councillor Burton. I have 3 questions. The first one was about assuring there was no window overlooking the neighbours to the rear. And I think you've already answered that there is no window overlooking. And I was also going to ask whether or not the roof lights were overlooking the window, overlooking the property to the rear.
To the rear, there is no roof lights in the rear.
Yeah, that's what I thought.
Yes.
I would love us to start adding a live link to the planning portal for each individual application as it comes through, so I can check these things when I'm here and there, just as things come along, so I can be more proactive in, rather than having to waste your time asking questions where I kind of could have worked it out for myself. I do have a question about parking though. When we lose a double garage, which I think we're going to in this case, and it's going to be turned into a family room. So the original plans would have taken into account there being off-road parking for 2 vehicles there, and now we're adding possibly more bedrooms and what have you. I presume there's going to be a higher number of cars that we need to find space for. Do we have a rule of thumb about that? Do we just say if you lose a couple of parking spaces within the curtilage, then there shall be two more parking spaces provided within the development?
I know the Highways Authority have raised no objection to it, but in terms of, it's a bit of a strange one because the view of the Highways Authority now is that garages aren't included within the numbers for parking provision anyway, on the basis that they might be used for other things other than parking. So I suppose it's just a case of if something's removed, that there's not going to create a problem. But it's, I suppose from the point of view as to why we've got no objection is because the removal of the garage wouldn't really be seen as making any difference to the site in terms of the local highways authority. So they would probably see it at the moment of having the parking outside of the garage would be the parking for that site.
Yeah, thank you very much. I don't think many of us actually use our garages for keeping our cars. Brilliant, thanks.
No further questions, Neil? Thank you. Stuart.
Thank you, Chair. Just for clarity, you said there was no windows looking onto the rear elevation, which I think there's a bit of a mix-up here because it's the west elevation you're talking about and there are windows on the west elevation. Am I right?
There's the ones at ground floor level.
There's one at ground floor level and there's 2 roof lights as well.
Yeah.
Thank you, Councillor.
Councillor Burfoot.
Thank you, Chair. I just wonder if the planning officer could just explain for clarity what criteria do we actually use to assess overdevelopment of a site, because I think that's probably going to be one of the issues that we talk about in the debate.
Yeah.
And the second question is, we've talked about the roof lights, which are in the what's called the storage area, which is presumably the loft. Could that become a habitable room?
It would depend on whether it would need building regulations, I believe, if they wanted to use it as a habitable room. But if it didn't create any external factors such as dormers and things, or be over a volume content of, I think it's 15 15 cubic metres, it wouldn't need planning permission. So in theory, it could be something that's changed, yes. And it's not something that planning would potentially be able to restrict. So we could, so there may be that in the future.
And just how we assess overdevelopment of a site. How do you, as planning officers, assess that?
Say HC10 is the main policy that we use for assessing development or overdevelopment. So unlike, I suppose, some councils or authorities that use things like design codes or percentages, we tend to base it case by case. So we look at things like the scale, the size of the plot, what may be around it, things that could be done via permitted development, take those into account, because there is quite a lot you may be able to do anyway. So but it is quite subjective, obviously. I did look at the previous one and put that forward for approval, because I thought the amendments did make a difference, but obviously the inspector made a different decision at the time. So it does show you how subjective HC10 particularly can be, because it's not set for, it's not got any caps. It hasn't got a particular, if it goes by virtue of, if it goes by this percentage, we don't allow it. It is subjective, but I feel that the amendments mean that it wouldn't be considered overdevelopment, but it is a subjective, as with every policy, I suppose, is subjective to each opinion, but I do think the amended scheme looks at what the inspector particularly picked up from HC10 and PD1 and has made revisions to it. And based on the scheme that they've put forward, which is what I've been asked to determine, I feel that enough changes have been made to address the comments and the issues that the inspector highlighted, where he felt that the previous scheme didn't meet the criteria of HC10 and PD1, but it isn't as easy as saying it's if it goes over a particular size or if it covers so much of a curtilage or something like that. It is more on a case-by-case basis, looking what's around it, looking where previous properties may have been developed in the vicinity. So it is quite an open-ended question. But,
Councillor Boynton.
Yeah, two questions, please. The first one, we've heard mention of an 80% increase in floor space. Do we know what the footprint increase is, please?
can do that for you. We've got a scale. It won't let me go on internet, so I'm going to have to do it the old-fashioned way.
While Gina is responding to that, are there any other questions? So there will be Councillor Peacock.
Chair, I've got a second question, please.
Sorry?
I've got a second question, please.
Yeah, that's absolutely fine. Yeah. I'm just determining while she...
Okay, so give you my second question now.
Well, she... Okay. I just thought we'd give her time and
that's
just
fine.
find out
Okay.
who wants to speak
Let's
after
do that
you,
first then,
John.
Thank you.
So let me get it right. There's Councillor Peacock. Neil, you wish to come back with further questions? Yeah. Anybody else?
I think if you do that, we talk. Let's see if I can actually get into anything. Yeah, well,
It's doing this on the hoof.
nope.
just like to bring Chris, Principal Planner, in, please. Chris.
Thank you, Chair. I just obviously Gina's seeking to do a calculation as we speak, but it's quite tricky to do on the hoof in a committee meeting. It hasn't been calculated by the officer because it's not a policy requirement to assess that, because the policy doesn't talk about percentages. We're happy to do an estimation now, but I would heavily caveat it that it's going to be an estimation based on the workings out that Gina is doing now. Might not be 100% accurate.
Yeah. With respect to the applicant, I cannot legally, I know you're trying to be very helpful, but I'm breaking my own rules if I allow you to contribute. Well, it's not my rules, it's the planning rules, sorry. John, what was your second question, please?
My second question, I believe the garage in its entirety is being demolished and the extension will be built effectively where the garage was. Now, my understanding is that the west side wall will be built further away from the boundary. And I'm just wondering if we know how much further away from the boundary that new wall will be as opposed to the existing garage wall.
Rosie, are you able to respond to that?
Yeah.
No, thank you. Yeah.
I've got the current footprint. This is caveated, as Chris says, of the garage and footprint of the dwelling to be 140.6 metres. Square metres. That would be, and the new scheme would be. This is footprint only. Removal of the garage would be 173.2, but obviously footprint doesn't take into account the fact it's two-storey and things like that, but that's on the ground. Yeah, and then you wanted the distance between the garage to the western boundary.
Well, the distance increase, if that's possible.
Yeah, of course.
Thank you.
I've got it on the same plan. It's about 3.1 metres, the garage currently away from the boundary, and the extension from the single storey part would be about 4.1, so it's about a metre difference. Yeah.
Are you okay at that, John?
Yes, thank you.
Yeah. So, Councillor Buttle, please, and then Councillor Edwards.
Hello there.
Well, sorry, I do apologise. No, you've been patient. Yeah, we'll take Councillor Peacock first, then Neil, and then Councillor Edwards. Sorry, Lucy.
Sorry, it was a request rather than a question, really. I think policy HC10 is going to be pretty key to this. So can we have... Oh, that's what I was going to ask for. Can we have the proposed... the plan of the site proposed versus current on screen while we're debating?
Yes, this is...
That's it,
want me
okay.
to leave it up, yeah. I'll try and go a bit further into it.
Any further questions, Lucy? No. Councillor Buttle.
Thank you, David. Looking at the picture that I saw a minute ago, it looked to me like there was a door and a window facing west, I guess, which is round about where we've got little red signs, yeah. Oh, you're going so fast.
Sorry, I'm rubbish at using this. I keep just using my mouse and you have to click it.
Right, brilliant, yeah.
Younger person, I think.
Yeah, the middle one at the top of that one looked like there was a door and a window facing towards the neighbour's property.
Yes.
Could we ask for that to be obscured as a condition? Is that a kind of conditionable thing, or is that something which we would not? And do we know how tall the retaining wall is going to be? Because if the retaining wall is higher than that, then that would be an unnecessary and unreasonable condition.
We don't have details of the retaining wall at the moment, but in terms of the condition, we could put one on.
Sorry, could you start again?
Sorry, I need to lean forward. I say we don't have the details of the retaining wall as such, but we could condition a obscure glazing condition if we felt it was reasonably necessary. I know I've put condition on at the moment just to prevent any further windows being added without our prior consent, so I could do something similar if needed.
And thank you very much.
Councillor Edwards.
Yeah, thank you, Chair. But my point has now been sort of answered. Thank you. No need.
Oh.
Thank you.
Okay. No further questions from Councillor Hughes. I'm sorry, Mr. Young, I can't let you speak.
You have the old application.
Sorry.
I'm just saying, I can't, as chair, allow you to speak.
I'll say it for him. He had, we saw that is the old application. That is the old version. But my question is about the western boundary hedge or trees. If those do need to be, can we condition that suitable planting is maintained along that western boundary to ensure the privacy and lack of the neighbouring property as part of this application, as part of our response to this application?
Yes, I think that is something we would be able to do, and obviously speak to Chris Payne for what we would see as fit and probably get it discharged.
So we could maintain the barrier that there is there at the moment with suitable planting.
I can't see any concern with that.
Thank you. Okay.
Yeah.
Now, can I ask members at this point, we're going to go into debate. To save some time, is someone prepared to actually put forward a motion either supporting officer recommendation or refusal? Councillor Lees.
Thank you, Chair. Some interesting questions, and unfortunately I'd like to move this against officer recommendation for the following reasons. Well, we've heard from the residents, etc., from roundabout, which concerns pretty well what I've got to say, basically. When the appeal was made, the result of the appeal, should I say, the officer that did the appeal stated that the two-storey extensions would detract from the well-proportioned design of the host dwellings, harming the character and appearance of the area. Further to that, I do feel that it fails and conflicts with policy PD1 of the local plan and framework, and I also do think it conflicts with PD6 with the loss of the hedgerow due to the fact we have got the retaining wall, so the vegetation will be moved out. And I do think as well it fails on HC10 by the design and scale and its settings and location. So that is my reasons for going against the officer's recommendation.
I think that's extremely helpful, Councillor Lees, in your moving of refusal. Does that find a seconder in committee? Councillor Dobbs. Peter, do you wish to speak at this point?
Yes, I will. Thank you, Chair. Yesterday on the site visit, Rosie, I gave you a view of various things in elevation showing the present, the one that was refused, and this current one, which we've now got on the screen. Is that available as a slide? If it could be shown, that would be enormously useful. Okay, well, let me tell you what I'm looking at and what Gina's looking at, which basically, in the two elevations that I've stacked on top of each other, have got the previous one, which, as Stuart has suggested, the inspector was less than complimentary about. If I actually go on, in actually the same paragraph that Stuart quoted from, he goes on to say, incongruous will be read as incongruous and unduly bulky in context, failing to successfully assimilate within the street scene. Inspectors, I've read quite a lot of inspectors' reports, they're not usually this brutal, to be honest, and I think would be really somewhat ill-advised to not take on board his comments, because to my reading of it, in terms of what I'm looking at now, is the difference between what he was so uncomplimentary about and this one is almost as if you'd taken a very sharp craft knife to the top right-hand corner of the property and sliced it off. I don't think it's done anything in terms of the elegance of the building. It might have sort of addressed the, well, there isn't a two-storey wall right against a neighbour's fence or close to a neighbour's fence, but it's also put an exceedingly significant extra extension to the rear, and I don't think it actually makes a very elegant building. It's quite an attractive building at the moment. As it was commented, the Shires estate is really quite something. It has space and it has these rather quirky little double garages with their pointed roofs. It's part of the character of the estate. And I think losing it would be a great shame. I think the inspector has made it very clear what he thinks about this type of development in this location. And I think we'd be well advised to take his comments to heart. Thank you, Chair.
Members, we've had it formally moved and seconded for refusal. Does any other member wish to speak? Councillor Slack?
Murphy was first.
Sorry, Councillor Murphy was first and then Councillor Slack.
Chair, I was just going to second what my colleague had suggested. So, Peter beat me.
Thank you, Dermot. Councillor Slack.
Thank you, Chair. Yeah, I support Stuart's recommendation for a refusal. It is overdevelopment, there's no doubt about it, really overdevelopment. And it must be if it was to go ahead, it'll be the biggest property in this estate. It's enormous, so it doesn't look completely right. It's too much development, so I'm against this. Thank you, Chair.
Councillor Boynton.
Thank you. Having listened to all the comments that's been made and also with the proposal, I've thought deeply about this, and the majority of this extension is at the lower level. The main issue seems to be the west facing wall and the view from the neighbour's point of view. If we take as ballpark figures a 25% increase in footprint, then the actual two-storey part of it that's by the west side is very small indeed. It's got a sloping roof on it, so there won't be the huge wall facing westwards. Obviously, the plans have been drawn together with the planning officer, and against most of the comments, I think that the applicant's taken a lot of time to come up with a reasonable design which will affect the neighbours an awful lot less than the first plans that were turned away. So I would support this application. Thank you.
Thank you for those comments, John. Any further, Councillor Peacock?
I'd just like to agree with that, actually. I'm looking at the elevations that Councillor Dobbs was referring to, and I think that does make quite a big difference. But also, I think we're putting too much weight in the inspector's report referring to the two-storey extension. The inspector was clearly referring to that particular two-storey extension, and I do think this one is really quite different to it.
Thank you. Any final comments? If not, I'll ask the mover of the motion to wind up, please, Stuart.
Thank you, Chair. Yes, I still go by what my motion was. It fails and conflicts with policy PD1, PD6, HC10, and I do disagree with some of the comments that I do believe that the inspector referred to any two-storey extensions on this. Like others, I can't see a problem with single-storey extensions, but any two-storey extensions, I believe that inspector stated that it was anywhere the two-storey extension, not just that elevation. So that's my reasons for putting it for refusal, Chair.
So, members, for those reasons that the mover has expressed, let me put it to the test. All those in favour that in fact this application is refused, please now clearly show. 1, 2, 3, 4, 5, 6. I might say. Yeah. 4.
No, again.
Against, sorry. Against 1, 2, 3. So it's 4 against. So the recommendation is carried, and the application has been formally refused. Thank you. If any members of the public wish to leave now, please. And so we turn to now page 24, 25 for our second application. This actually was, I think, our first site visit yesterday, which is the Middleton Top campsite, Rise End Middleton by Wirksworth. Do we have any speakers?
Yeah.
Thank you. So can I invite at this point then Dr. Andrew Quigley, local resident, who I understand is speaking against the application. Andrew, you've got 3 minutes.
Thank you, Chair. Good evening, committee members. I reside at 19 Rise End, close to the campsite. Locals are very unhappy about the unauthorised use of the barn. Just 6 people in total objected to the 10 most recent Rise End planning applications. This time, 17 Rise End residents and 3 others objected, 33 times the average, an unprecedented level of objection. Other residents felt equally unhappy but unable to write letters of objection. Both groups object to the applicant's cavalier attitude to planning. In plain sight, he has been blatantly ignoring the rules the rest of us comply with. So far, he has covertly lived in the barn for over 4 years, joined more recently by his new wife and her children. Facts known to planning for 17 months. The applicant would never have applied for planning had he not been forced to do so. Locals already consider there is a planning Wild West. If granted today, it will confirm that planning enforcement is weak. You can now ignore planning law and get away with it. A precedent which may well encourage other Dales barn owners to take the risk of covert development. Every objection contains solid planning reasoning. We all expect planning conditions to be fully adhered to and enforced equally. Granting permission will be seen as rewarding non-compliance. I suggest that the barn be returned to comply exactly with the 2015 approved plans. A simple utility building, no first floor, no external stairs. None of us want to be back here in 2 years' time complaining that the barn is now an Airbnb venue. I move on to the new build. This is the partially built dwelling that the applicant cites as the reason he needs to live in the barn. It became apparent during construction that the new build would be very much more obtrusive than we were led to believe. Revisiting the approved elevation drawings, I found that it had been built several metres higher than shown in the plans. Following professional advice, I formally complained to planning. I expect there to be no further building work and for a new application to be invited so that the impacts can be fully understood and a decision be taken based on accurate information. I know that enforcement is investigating this issue. I hope for an acceptable solution. However, I feel very strongly about this. If necessary, I will escalate this issue as far as I am able to reach resolution. The new build is not capable of being implemented in its current form. This issue could result in a significant delay.
Dr. Quigley, I'm afraid your time is up. Thank you for... Helen Moxon, please, local resident and joint owner, to speak against the application.
Right, good evening, committee. I'm here to formally object to the planning application concerning the property at 20 Rise End and the associated barn, campsite and part-built new build, which I jointly own. The premise of this proposed permission is based on the presumption that living in the barn is an alternative to living in a static caravan on site for the purposes of continuing to build the new build. First and foremost, I wish to make it clear that this application has significant personal and legal implications for myself as the co-owner. The proposal would allow my ex-partner and his new wife and her family to remain on the site, which I jointly own and live at, as I have for 18 years, for up to 2 more years, with the possibility of further construction during that period. This extended occupancy and potential development are not agreed by both owners and would directly affect my rights and interests in the property. As a joint owner, I'm entitled to have my views and consents taken into account regarding any changes of development or developments on the site. Allowing this application to go ahead would effectively disregard my position, potentially undermining my ability to access, utilise or manage the property fairly during the proposed period. I'm concerned that granting this planning permission could set a precedent for ignoring the rights of co-owners in such matters. Since my ex-partner's departure into the utility barn 4 years ago, I've been engaged with a solicitor to try and resolve the situation. Granting of this permission will just add further complications to an already difficult situation, financially, practically and emotionally. Committee need to understand that this is a retrospective application, forced by the objections of local residents. The applicant had made alterations to the barn to facilitate his and his new partner's occupation. This was without recourse to yourself, myself, or any other regulatory body. He has also contravened the permission granted on the campsite, again without recourse to anybody he should. Moreover, there's been insufficient communication and consultation around this application. As a co-owner, I have not consented to this development and I am concerned that the process has not adequately considered the view of all stakeholders. I respectfully urge the committee to recognise the importance of clear mutual agreement in planning decisions, especially where ownership is shared. This has not been addressed at all in section 7 of the officer's report to Planning Committee. So in summary, I strongly object to this planning application. The time it will take for all due legal processes will potentially exceed the 2 years applied for.
Thank you very much.
Okay, thank you.
Harris. And then I invite the ward member, Councillor Lucy Peacock, please.
We've got
Sorry.
Cheryl Harris next.
Oh, sorry. I apologise. It's Dr. Cheryl Harris.
Thank you.
Getting ahead of myself.
That's okay.
Yeah.
So I have 2 points to make alongside an alternative proposal for the committee to consider. Point 1. The main argument being made by the applicant is to allow the use of the barn as accommodation during a house build. Apparently, this is a relatively common application ask, but one which is always or nearly always refused. So when might it be considered? Occasionally, temporary accommodation outside a settlement boundary is deemed acceptable if there is clear operational reason, it is simply not for convenience, for example, an agricultural worker dwelling whilst establishing a farm, the building is suitable and easily reversible, the duration is strictly limited with a 100% guarantee from the applicant that their proposal is achievable, and there is no viable alternative accommodation nearby. This application does not meet any of these criteria. The key takeaway that this is uncharted territory. The application goes against key policy considerations, having the potential to set a dangerous precedent if approved, and thereby opening the floodgates for others to follow suit. Temporary conditions are also difficult to police and lead to unnecessary increase in caseload. Rightly so, and as a rule, councils prefer clear, permanent permissions or refusals. On the point of ownership, and expanding on what Helen Moxon has just said, planning permission does not equal the right to implement or override property rights. So this, you recall that this property is co-owned and both parties are currently in dialogue to resolve ownership issues. Even if the council grant permission for a temporary use, the consent can only lawfully be implemented by someone who has a legal interest in the land, i.e. owns it outright. If there is a dispute between co-owners or one refuses consent, whilst this permission may exist on paper, it cannot be enacted. Respectfully, the council's take on this should be that there is no certainty whatsoever that its proposed development could be implemented or cease after 2 years as claimed by the applicant. The site's co-ownership issues and lack of control introduces huge uncertainty and a real risk that this proposal would not be temporary or reversible as suggested. This is the killer blow to the proposal, i.e. it fails the test of deliverability, and even with the best will in the world, there is no clear exit point. No one can be satisfied that can it be implemented in this 2-year window. This is a valid and robust reason to refuse. So in summary, if permission was granted, enforcement becomes messy and will apply to both parties. Would the council really want to inherit a potentially unenforceable condition?
Unfortunately.
I've just got one proposal, which is instead to grant the applicant a period of 3 months residency whilst they seek alternative and more suitable accommodation. Thank you very much.
Thank you very much, Dr Harris. So it is now the ward member, please, Councillor Peacock.
I'm not going to talk for long. I objected to this, and part of the reason I objected to this was because I wanted to reflect the opinions of other villagers who didn't want to put their name, who didn't want to object in public, basically. And the reasons that those people objected were, broadly speaking, what you've just heard, that people really don't like it when they see somebody breaking the rules and appearing to get away with it. That's one of the main objections. The other one is over the 2 years, because of the complicated legal situation, it is quite unlikely that the house referred to, the new build referred to in the section 8 of the report, in the first condition, it's highly unlikely that that will be finished in 2 years, which puts the whole application into question, and finally because of the precedent it potentially sets. That's all.
Thank you very much, Councillor Peacock. So I invite Amanda Mansfield, local resident and interested party, to speak in favour of the application.
Thank you. I've got an MBE after my name, so I'd like that on the record.
Sorry?
I'm an MBE, so I'd like that on my record because that's what I submitted my response to. So that needs to be in my title.
Yeah, so you're a member of the British Empire.
I am indeed, yeah, thank you. So, committee, thank you for hearing. I'm a resident and I would like to declare that I'm also a friend of the applicant. As part of this, I reviewed all of the submitted documents and the application, also including all of the comments for and against this proposal. I don't have a planning background, but I am a professional person. I have noted many personal comments that I felt were out of scope for the purposes of the determination. The temporary use of a barn for 2 years is the least impactful option versus having a caravan on site. Not only from that point of view is it a financial and an economical impact for the applicant and his family, but actually it is the least impactful option in terms of the impact on the environment. So the barn as it is and as it stands does not have any external impact as it's currently lived in. Up until the point of this application, there were no recorded previous complaints by any of the people that opposed it online regarding the barn. That was to the neighbours or from the public regarding this, albeit that land and the barn had been lived in. So none of that was raised before this application was put in. In terms of what I don't feel has been adequately captured within the scope of this, and it is a point that isn't either in the planning report, is that the impact of having a permitted development in terms of a caravan on site would cause more impact and cost to the environment than the existing request of the applicant, that is, to have that 2-year period of temporary residence in the accommodation. I also note, having read the Highways Agency report, the Wildlife Trust and Environmental Health, that they raised no concerns regarding this application. So, lastly and most importantly for me, is that the scope of this is to consider a 2-year temporary residence in the barn as it is. It's not for us to judge what happens beyond that. That is for the planning system. So based on the application and for reviewing all the comments, and I don't have a background as a planner, and I think that's really important to say here, I'm just a general member of the public. But actually, if it were anything other than Richard, I would still feel the same, that I would just support this application. So I think I would ask this, consider that, because there's a lot of personal comments and a very complex situation that makes it unique. Thank you.
And then finally, the applicant who has 5 minutes, Mr. Richard Storm, unless you've got letters behind your name. Have we got to know?
I wish I had now. Very impressive.
Yeah.
Good evening. Thank you for the opportunity to speak. And I ask the committee to note the Planning Officer's report supports this application. I have cooperated fully with building control and planning throughout this process. All works are safe and compliant to the relevant building regulations and standards. I need permission to remain on site temporarily to finish the build, which people have referred to. Materials have been removed from the site without permission, and it requires someone to be present on site to ensure the completing of the work and security of it. The barn is warm and avoids the need for an unsightly, large living caravan, a safe place to live. There are several supporting statements confirming the site is best maintained and managed by having someone living on site. Under permitted development, I have the right to live on the site while building. I'd like to address some of the points that were in the complaints about it. So there was an allegation of perverting the planning process, which has been raised during this. My move into the barn was unplanned and arose when I separated from my ex-partner, allowing her to live in the family home where she still resides. The planning authority have been aware of my circumstances for several years and have accepted my occupancy. When asked to formalise my position, I submitted this application. I have been open and cooperative at every stage. The only distortion of the process has been one small group of close associates producing multiple objections based on speculation and a shared document commissioned by Andrew. This has caused unnecessary stress and expense to my family and the local authority. Allegations of significant unauthorised changes. The works are internal, would be within normal permitted development. The only consent required is this application. Allegations the impact on the landscape and living in the barn is out of keeping. The barn has stood for several years and its appearance has not changed. I am quietly and respectfully living there, and I haven't changed the surrounding characters. The claim the Camping Caravan Club has closed us and we're under investigation. This is completely inaccurate. The site is not being closed and we're not under investigation. It just shows the level of speculation that's been going on around this. A deliberate campaign of some objectors devaluing the business and misrepresenting the facts has led to these objections. This has required me to take some legal steps to address that. The allegation is irrelevant and to the use of the temporary building. Allegations operating beyond permitted campsite occupancy has not been raised today, but it's within there. The site has hosted whole site bookings or rallies. This is something that the complainants have approved of for years. Councillor Peacock herself booked the site for a significant birthday attended by all the complainants that you get here today. Rallies have not caused issues and they support local events. This matter is not relevant to my temporary accommodation. Allegations about using it as an Airbnb. Airbnb is merely a booking system for things I already have planning permission for, and it's not relevant to this allegation, to this application. Allegations about joint ownership and no consent. It is true my ex-partner has not consented to all the works. I have always acted within the law, and when I have asked her solicitor could not substantiate any grounds for objecting, neither to my residency nor to the continued building works. So there is not a legal argument about this. She continues to occupy the family home, therefore I require temporary accommodation to build my own home. This matter so it doesn't really relate to the temporary use of the barn. In summary, the planning officer supports this application. I've been open and cooperative. The barn is suitable, safe for temporary home while I complete the build. And many of the objections raised are either already addressed by the officer's report and are not relevant to the application, and I'm happy to answer these. And the allegation that Andrew has brought forward about the building not being
Thank you, Richard.
appropriate.
That concludes your time. Thank you. So I'll invite now the case officer, please, to outline the application which is designated for approval.
Thank you, Chair. This is a planning application, a retrospective planning application that's been submitted to us for consideration following the guidance of the enforcement officer for a temporary use of a barn as a dwelling for a further 2 years at Middleton Top Campsite. It's an existing barn that's already been adapted, particularly at first floor level, to provide residential accommodation. Say they're seeking to get a legal, to formalise it for a period of 2 years while they continue works on the previously approved dwelling that's at 20 Rise End that is has commenced construction. This is one that's somewhat, obviously with a lot of policies, they're based on permanent changes of uses, but we have to take it, so we do have to apply the policies and take into consideration the comments of consultees and neighbours. But we also need to take into the fact that it's a material consideration that it is only for a temporary period. I've tried to balance that in my report, and also acknowledge that if it was to be for permanent a permanent residence, that we wouldn't consider it to be suitable. That for perhaps for a temporary continued period, it may be livable, but it's not something we would see as a permanent form of accommodation. So on balance, based on the application being put forward to us for formalising an existing arrangement, what we know of the works that have been done and the policy, but also the material consideration of it being temporary, I on balance made a recommendation that it should be approved for a further 2 years and conditioned it as such. But obviously that is up for debate now. Thank you.
Thank you, Gina. Now, members, before we go into questions, can I draw to your attention correspondence received after publication of the agenda, and I would like members now with care to read the letter from Dr. Quigley reiterating objections to the applications and concerns with the previously approved dwelling which has been partially constructed. So that's on page 1 of the sheets in front of you. So, members, we've listened with care to representations. We've read that piece of correspondence. It is now open for questions. Councillor Boynton.
Yeah, can you clarify, please, the relevance of ownership of property in planning terms over numerous references to ownership?
In terms of ownership, a subject that the application has been made and a declaration, as a certificate of ownership has been served, you can issue a planning application or a planning permission, and if there's disputes over things like land ownership, it would be a legal matter between the applicant and any other interested parties. So, in terms of legality and things around ownership, it is something that the planning authority don't have much of a power over.
Can I just bring in at this point the council solicitor, and then it will be Councillor Slack, Lees and Dobbs.
Thank you, and through you, Chair. I know the question about ownership disputes may come up, and just to reiterate what Gina says, ownership disputes are not planning matters, and this committee is not responsible for resolving any ownership or consent disputes. Just to give you a little bit more information, what planning permission does not do is it does not override anybody's property rights. It does not require all of the owners to agree. And lastly, planning permission is not a grant of development rights, it's only a permission to proceed if they are legally entitled to do so. So even if the co-owner does object, this committee can still approve the application if it does meet planning policy. Just to go a little bit further than that, so if the application was approved, the co-owner may still have, they do have legal options. It's outside of the planning remit, and they do have private legal action that they can take. And I would urge that don't take my advice because it's not advice to them, but they do have their own remit to seek their own advice. And just by that, coercively, the applicant may face any delays or legal costs if they do proceed without resolving any ownership issues. So yeah, just to reiterate that you as planning committee members are not here to resolve any planning disputes in that sense, ownership disputes.
Thank you, Kerry. That's very helpful. Councillor Peter Slack.
Thank you, Chair. Thank you, Kerry. I was going to suggest that you put those views forward. It's a very difficult situation, and my question is that yes, we can go ahead and look at it, but my suggestion would be to go for a deferral till we can get to the bottom of this. Really, it's a very difficult situation we're facing now.
Well, with respect, that's not a question,
It's not a
Peter. That
question,
can come
no.
up in a few
Would it be
moments
possible?
when we
I'm
get
asking.
to a debate and a motion.
Would it be possible to go for a deferral? Ask the solicitor.
Well, we're in question. I think that's a legitimate thing you can propose, but we're not at that stage just at the moment, Peter.
I'll leave it for now then.
So, Councillor Lees.
Thank you, Chair. Can we just be clear? We're only looking at the temporary accommodation. We're not looking at the park building, are we, at all? It's just, it's been brought up several occasions, but we are looking at solely at the temporary accommodation for 2 years. Is that right?
Yes, this application is just for the temporary use of the barn for a further 2 years. It doesn't involve the campsite or the previously approved dwelling.
Thank you.
No further questions, Stuart? No. Councillor Dobbs.
It just builds on Stuart's question, just to absolutely clarify, it's not material to what we're deciding now about the height of the new build or the possibility of the new build being delivered in 2 years. It's completely irrelevant to what we're deciding.
This is just looking at securing or looking at formalising the temporary use of the barn. It doesn't involve the dwelling on site or the campsite or anything like that.
Thank you.
Councillor Hughes and then Buttle.
Thank you, Chair. It's another clarification. I'd just like it clarified that it's normal for if an enforcement issue, if enforcement is considered, that the property owner can come back and put in an application, and that's perfectly normal and happens regularly. Is that correct?
Yes, under the Town and Country Planning System, we do allow for retrospective planning application, and that is I suppose, a way to resolve some enforcement matters. So it is something that's been obviously picked up by enforcement, and then an application's been put in for us to determine. So it is something that does happen regularly, that we would receive an application after the work is done, and we still have to consider them as we would a normal application.
And is that one of the first proposed actions that would be proposed, rather than going to a full enforcement? You would suggest perhaps that somebody puts a planning application in.
I don't tend to make that sort of recommendation. It tends to sit with the enforcement team, but obviously they've got a raft of different options for enforcement. So I would imagine that on balance they would recommend what option they think, whether it would be cease operation, put an application in, or further action. So I imagine that would have been the advice of the enforcement team. So I'm not involved in it, but I would imagine if it's not gone to appeal or further action and an application's come in, that's sort of something that the enforcement officer would have considered at the time.
Councillor Neil Buttle, your questions.
Sorry about the wobbliness. Thank you. I've got a couple of things which sort of caught my eye as the public spoke, as it were. Dr. Harris mentioned something about the certainty of a temporary use, change of use, being ended. How do we normally judge that? Is that actually a thing? Like, if we are offering a 2-year temporary use, change of use, do we actually have any enforcement there, or is this like we've already got to this stage and then they've made an application for a 2-year change of use? So then in 2 years' time, do we get another year's change of use application? How how does the enforcement fit within this?
Chris? So I can answer that question. Obviously, if planning permission were granted for a temporary 2-year period tonight, officers would note that, and we've got systems for noting that. In addition, I'm sure given the level of local interest, local residents would alert us to the fact of any breach if it went on beyond the 2 years, and then it is for the local authority at that point to decide whether to take formal enforcement action. It would basically be a breach of planning condition, because if permission were granted on a temporary basis tonight, there would be a condition requiring that to be limited to 2 years, and so it would be a breach of condition notice that would be the option available to the council to serve if residential occupation continued beyond the 2 years.
Can I come back, please?
Absolutely.
How do we prioritise the different demands we have on our enforcement team?
I mean, in large part, it's down to what local residents require us to treat as a priority. So if there is concern amongst local residents about a particular breach, then that is always something that the authority will investigate and ascertain whether there has been a breach, and if so, obviously to prioritise getting that resolved one way or another.
And just to be clear, the question about whether or not there will be any certainty is not terribly relevant. The granting of the granting a temporary residence, as it were, it's just like we have to expect people to be people and things to change.
Chair, again, I'm happy to answer that. I mean, I think that's a correct summary of the position. I mean, any planning permission, I suppose there's always a risk potentially that it might not be implemented properly, but the assumption has to be that it will be. But obviously, if it becomes apparent at any date, whether it's a new dwelling, a new permanent dwelling, a new temporary dwelling, a new commercial premises, if it becomes apparent that that is being built or is operating not in accordance with the approved plans or the approved conditions, then obviously the various options are open to the council to enforce. But in terms of assessing the application, it has to be assumed that the applicant will carry out the permission as applied for and as conditioned by any relevant conditions.
And finally, this is slightly more speculative. As the planning regimes change according to governments and what have you, and the change of planning frameworks and the process and local government reorganisations, do we actually feel that we will be in a position to enforce anything in 3 years' time, 4 years' time? Where and what are we just sort of hoping here?
So I don't think that it would be reasonable to give significant weight to the fact that there would be that there's likely to be local government reorganisation in the future, because any new body that takes over responsibility for the planning function, it would be their duty to then also to enforce any matters at their discretion which they consider are expedient to enforce, just in the same way as Derbyshire Dales would.
No, thank you very much.
Can I just say, Neil, I, as chair of the committee, I compliment you on that first question. I think it gets to the crux of the experiences from most of us as ward members, so thank you for asking that. Councillor Slack.
Just one question. In regard to the other property, when did it get planning permission for the alterations? And is it relevant? It is mixed with this application because they can't move till he's built this, completed this. So how long has it been ongoing, this?
It was approved, I think, in 2019. It was by my former colleague, Gareth Griffiths. I know it's commenced works, and on the as condition of the planning of all planning applications is once you make a lawful commencement, you can work in, it is live in perpetuity, so we can't enforce somebody to do it any faster. We can, but it's very difficult to do so. So at the moment, what I've tried to do is give weight to the fact there is a house being built with the view of somebody living in it. I've tried to give that some amount of weight because temporary use of a barn is attached to something, because in theory, in 2 years' time, there will be somewhere else for them to live. But obviously, if that doesn't turn out the way that it might do, or the way that it's put forward, the decision will lapse at some point anyway. So it would be something, if that still hasn't happened, I would expect potentially another application, or we'd have to look at it at that time to decide what to do next. But this is on the basis of there is a partially constructed dwelling, and there is obviously legal issues and things around it, but that is in perpetuity now. And we've got to have taken that into consideration. But if there isn't any movement and things on it, it would be something that would have to be looked at after the 2 year period, I think, as to whether that changes the position of it.
Yes.
You said back in the 90s. You did say the 90s, didn't you?
I think I said 2019.
When the approval was granted back in the 90s.
No, I think it was 2019.
2019.
2019, okay. My year is such. But 2019. So it's quite a while ago now, isn't it, really?
Yeah.
And it's not been completed. And that's so on that evidence, it doesn't look like it's going to get completed in the next 2 years, possibly. I know that's not a question.
I think we're digressing there, Peter. So
the question is, probably rephrase it. The question is, if it's not completed in the next 2 years, the enforcement will have to come in, won't it?
It would have to be something that we'd consider it again, because at the moment we have got obviously a dwelling that's been started within the 3 year period.
Yeah.
We'd have to see at that point whether things had changed, whether there had been more to it. But I think at this point we've got to take into consideration it has commenced.
6 years ago now. Yeah. Thank you.
Questions from Councillor Suber for anybody else after Sue? No? Right, Sue.
Thank you, Chair. Just to be absolutely clear, am I correct that if we were to give planning permission tonight, there would be no external alterations permitted to the barn, and that when the house is completed, the barn reverts to its former use as a barn and doesn't become residential accommodation? How do we put that in the in any permission that we give?
I have conditioned it so it's 2 years, and after that 2 year period, if it was granted potentially today, the barn itself should be returned to its previous use, which was storage in connection with the campsite. And there is a condition on there as well to say that there can't be external alterations to it. This is just all they've put forward is the use. They've not put any forward any alterations, and we wouldn't expect that either, because this is for a temporary period. So I've put that on as a condition. We wouldn't necessarily be expecting any further changes to the building because of the temporary nature and the fact that we expect it to be returned. So they have been conditioned as such.
May Chair, what about the possibility that it might then become a residential accommodation in its own right? Would that be something that could be put forward and would be considered as and when?
We have only,
if that makes sense.
Yeah, we have only, obviously this will be conditioned as not as a dwelling, it will be for temporary purposes of accommodation. So obviously if you try to make that argument at the moment, it is just for temporary accommodation. So it would be something that we take into consider, and I have tried to consider in my report that there is certain elements to it that you know, it may be appropriate currently for temporary accommodation that it's been used for, but it's not something that we would support as a dwelling. So the fact we've sort of conditioned this as such, yes, it might be dwelling for a temporary period, but it's not something we would seek for a permanent residence, and that would be reflected in the decision that we granted as well.
Okay, thank you.
So I thank members for the questions. To help have a focus rather than a long debate now, is someone prepared to move the officer recommendation? Councillor Hughes and Councillor John Boynton. Councillor Hughes, would you like to? Right, it's been, you're moving the officer recommendation. Yeah, it's been moved and seconded. John, do you wish to speak?
Just briefly, I've listened to all the representations, and I've also noted Councillor Slack's suggestion of a deferral. But having listened to the representations, I fear we're in danger of getting dragged into a civil matter here. So I'm quite happy to go with officers' recommendations.
Thank you very much, John. Does anyone else wish to speak? You've got a motion before you. Councillor Slack.
Yeah, thank you, Chair. Yeah, it's a very difficult situation. It's we are moving into an area which is beyond planning. So really, a deferral would have clarified it better. See if this building would have been completed in 2 years. We're not certain it will be, are we really? So. On current evidence, 2019 is a long while ago now, so he should have completed that in that time. So it doesn't look to me as it's going to be completed in that 2 years. So I think we'll be back here again in 2 years' time if we're still here.
So, members, it's been moved and seconded that we support the officer recommendation of approval. Will all those in favour please clearly show? Against? One against. Any abstentions? And one abstention. Was that a bit too quick there? Yeah. Can members just show again? All those in favour of officer recommendation? Against? Two against. Any abstentions? No. Therefore, that motion has been carried. Thank you. We turn then to our third application, found on pages 33 to 38. And I suggest that after this application we have a short break, please. So this pertains the Derbyshire Dales District Council variation of condition 2 of application number 2400542, full proposed installation of 12 number solar PV panels on roof on rear of building and proposed installation of air source heat pump to replace gas boiler. I'm not aware of any comments or representations, so Edward, are you leading this one?
Yes.
Thank you. Just allow Edward a moment. Are you going, Gina?
Chair, point of order. Chair, point of order. Given the nature of this application, which is to put solar panels on a building, we do normally that would we wouldn't need planning permission to do that. We're only bringing it to committee because it's Derbyshire Dales. I move officers' recommendations on this amount.
Does that find a second? Councillor Neil Buttle, a second relief of Edward.
Can I just bring up to your attention, Chair, is there a misprint or a typo? Because it says application relating, the same application number is the same for the one at Bradley as it is for this Northwood one. Am I looking at mine, was it? when it says on the speaker's rep, it refers to that application number.
Chair, I can confirm that's a mistake.
Thank you for being on the ball, councillor. So we've got a. Sorry.
Can we just confirm who's second? It's a bit of a fight.
It was proposed by Councillor Hughes and seconded by Councillor Buttle. Yeah, yeah. All those in favour, please, of the officer recommendation. Against? Any abstentions? Therefore, that was carried. I propose we have a short break now, please. How long do we normally have?
You can 5 minutes, 10 minutes?
A 5-minute break, then, if members wish to have a drink or go to the toilet. Thank you. Proceed into the Lumsdale Mill application. You've got before you the correspondence received after the publication of the agenda. So if you'd like to take a few moments with care to read the correspondence from Richard and Ruth Longfellow, is that right? Longfellow? And they're raising concerns in relation to the revised plans, impact on trees, drainage and construction phase impact on road and footways. So as we move into determining the application, can I first invite Mr. Neil Richards, local resident, to speak against the application. And Neil, you've got 3 minutes.
Thank you very much. Right. Okay, thank you very much. Thank you very much for the opportunity to speak. I'm here to object to the proposed development at Lumsdale Mill, focusing on harm to the existing residents, flawed access assumptions and the misapplication of planning policy. The new build houses, particularly adjacent to Radford Row and Leywood House, will cause serious harm to residential amenity. Radford Row faces 3-storey elevated new dwellings directly below, with overlooking loss of privacy and visual intrusion. Leywood House, a historic property to the east, will suffer increased noise, loss of privacy and disruption to its tranquil setting. These impacts are acknowledged in the officer's report, but downplayed. They're significant and contrary to policy PD1, which requires protection of neighbouring amenity. The layout creates overlooking, overshadowing and visual intrusion, rather than a coherent and respectful integration. A simple solution of making these 2-storey rather than 3, basically the loss of a garage, would keep the height of the development at the current level of the mill buildings. The majority of these properties are going to have 3 refuse bins. They'll be located in full view of Lumsdale Road. This is visually intrusive and easily avoidable. Why can't they be located to the rear of the site, screened from public view using appropriate material to the heritage setting? The same as every other property, they're brought out on bin day. The officer relies on the tilted balance due to the council's housing shortfall, but this does not override clear policy breaches. The scheme conflicts with policy S4. It is not adjacent to a defined settlement. It causes harm, defined as less than substantial harm by the planning officer to the conservation area, but nevertheless harm. Loss of employment land and amenity impacts. The benefits, 23 homes, do not significantly outweigh these harms. Tilted balance is not a blank cheque. It still requires a judgment of proportionality. and here the application should be refused. The officer also assumes unrestricted access via Lumsdale Road. This is incorrect. The lower section is actually a private road, and already in a very poor state, and I can't see anywhere where permission has been obtained for its use. The valley attracts heavy tourist traffic, especially during peak periods, when the road is often completely blocked by parked cars. This is real, recurring hazard for us residents, emergency services, and for future occupiers as well. The transport statement, a desktop exercise, fails to account for this reality. It's based on standard traffic models, not the lived experience of this unique location.
Mr. Richards, I'm afraid that's... Yeah.
Thank you.
Would Stephen Burgess like to come, please, and address the Planning Committee? And again, Stephen, you've got 3 minutes.
Okay, I'm Stephen Burgess. We live in Leywood House, which two sides of our property border onto the mill. I'd like to thank the committee for the opportunity to speak today. I object to the proposed development of Lumsdale Mill, and I'll focus on 3 areas: limited recognition of the written concerns, protection of trees and wildlife, amenity impact, and I'm talking there specifically around emissions and misleading information in the material provided. Detailed written objections. I believe there were 24 letters of objection put in. Other than a very simple list of headline topics in the officer's report, this does not describe or address the significant objections from adjacent neighbours and other interested parties. It skirts over all of that. The issues raised not only impact individual amenity, but also the protection of Lumsdale as a conservation area in its own right. This is despite these letters offering pragmatic options that would provide some level of impact mitigation. These appear to have been ignored. Protecting the trees. A significant number of healthy trees will be removed, especially along the boundary, several of which could remain with only limited impact on the design. Other mature trees will be impacted by building work and will be lucky to survive over time. These trees protect wildlife and provide privacy. Several are being removed only to provide parking, which could easily be moved back to 2 or 3 metres to allow the trees to remain. These trees offer ready-made screening for surrounding properties and are a major conservation area asset, which new planting will take tens of years to replace. If this is approved, we'd like to make some recommendations, and that is that a more detailed plan should be prepared for the trees with involvement of neighbours prior to tree removal, because once you do that it's too late, they've gone, with screening being a key factor. Any new trees should also be mature and substantial and not small and take tens of years to grow. Accommodating wildlife. The site supports a range of wildlife not apparent at first sight, including some protected species. If this is approved, we'd like the neighbours to be involved and could be seen added to the checks required under obligation 4C. Finally, I'd like to point out that omissions and misleading information in the plans that were highlighted in the letters submitted in the consultation period have not been addressed. This is especially true with regard to amenity impact on Radford's Row and Leywood House.
Okay, Stephen, that concludes your time. Thank you. So I invite now the ward member, Councillor Joe Linthwaite, who attended the site visit yesterday. Thank you for coming as ward member, Joe. And you've got 5 minutes.
Thank you, Chair. Good evening, and thank you for having this time to respond to the Lumsdale Mill application. This evening I'm wearing my ward member's hat, but I'm also wearing my déjà vu glasses. Almost 2 years ago to the day, I spoke to this committee regarding another application, and one issue I raised at that hearing is still pertinent today. The combined sewer that runs the length of Lumsdale and joins the Tansley network at Webster's Terrace. This system takes foul water from the properties in Lumsdale, some of the Chesterfield Road properties, Thornbury's and Cardenshaw developments, plus the Hazel development. 2 years ago, you saw photographs of the mess created at Radford Row when the manhole there overflows with raw sewage and associated paper products. This continues to happen. In 2022, the Webster's Terrace Junction discharged raw sewage into the Bentley Brook 41 times for a total of 212 hours. The latest figures for 2024 are 76 discharges for a total of 440 hours, almost double, and that is before Hazel comes on stream. The addition of another 23 homes on the Lumsdale Mill site can only exacerbate the existing and worsening situation. Of course, I understand that this is a Severn Trent water problem. However, our residents have to live with this until such times as Severn Trent decides to rectify the problem. My reason for mentioning it again tonight is to have it on record that Severn Trent has turned a blind eye to these discharges for another 2 years. Derbyshire Dale's own strategic flood risk assessment, section 9, 9.1.1, states, NPPF requires strategic policies and their supporting SFRAs to consider cumulative impacts in or affecting local areas susceptible to flooding. Please consider this cumulative impact this evening. I welcome the plans to develop and preserve the mill buildings. It is a concern of mine and the local community that if the mill buildings themselves are not restored and adapted first, there is a danger of them being left to further deteriorate whilst the new, easier to develop homes are completed. Should the committee vote to approve, could I ask for a condition for the work to be completed on the old buildings first? Trees. There are a number of mature trees across the site. As you saw from your visit yesterday, the architect's drawings indicate that some of these trees will screen the new properties from those on Radford Row and Leawood House. As you saw, these mature trees offer very little screening as their crowns are considerably above the levels indicated and therefore offer almost no screening at all. I would ask the local residents are included in any conversations regarding landscaping and decisions over which trees are to be removed or replaced. I would also ask that the removal of mature trees is kept to an absolute minimum and any replacements are of significant height and not simply saplings. I appreciate that there is indeed quite a gap between the planned rear walls of the two sets of three-storey homes backing onto Radford Row itself and the front of those cottages. However, as these cottages have no outdoor garden space other than at the front, the impact from overlooking new builds is of greater significance. The proposed rear terraces and windows are, in my opinion, overbearing. Please take this into consideration when debating the application. Do we have a definitive height measurement for the roof lines for all the new properties backing onto Radford Row and Leywood House? Existing properties may well be on higher ground, but screening difficulties make this measurement critical. Please note that the water supply for Leywood House runs across the Lumsdale Mill site. It was supposed to have been resited many years ago. If the committee is minded to approve, could we please have confirmation that this will be included in the required works? And finally, it became clear during the site visit yesterday that no account has been taken of the spring that runs on the mill side of the wall opposite the Radford Row cottages. Again, if the committee are minded to approve, please condition a proper survey and drainage plan for this watercourse. Thank you for your attention.
Thank you, Councillor Linthwaite. Councillor Linthwaite, as we all recognise, is a very committed ward member, and I just wonder, out of the earlier comments pertaining Severn Trent, is there not anything, Chris, that we can do as a planning committee to firm up and sort of say, you know, where are you going with these matters, or it still remains, you know, not just a concern, but we're looking for action and want to know what you are intending to do to...
Chair, I completely understand the concerns, but I'm not sure they... I'm not quite sure how that would relate to consideration of the planning application. I'd sort of defer to my legal colleague as to advice on the appropriateness of the planning committee making a resolution on that matter.
I don't want to confuse. I accept we're here to discuss this particular planning application, but are we not able to convey that out of our discussions members remain concerned or are hoping that Severn Trent is seriously looking towards resolving these issues that Councillor Laithwaite's made us aware of? You know, it just seems to carry on and carry on. Is that fair? Or
through you, Chair. Yeah, and I mean I certainly understand the you know, the rationale behind it, but this is the planning committee, and perhaps planning policy you know, that would be better placed to address those concerns. But I certainly would urge any councillor to approach any officer who is responsible for those matters and have open a dialogue with them and see what what they can do to contact Severn Trent.
just before I move it on, I am concerned, Joe, and I just wonder if perhaps a notice to full council that perhaps the council does seriously lobby Severn Trent. That might be one way of progressing. Councillor Lees.
Can I just point out, Chair, the recent seminar, wherever it was at Carsington Water, the Chief Executive of Severn Trent Water, Liv Garfield, stated publicly that sewerage wasn't a problem for Severn Trent. They could cope with it. It was the rainwater that they couldn't cope with. But that's what the statement that they came out with at the presentation. Quite a few of us from the council were at that presentation, and I'm sure they'll remember that. So just a point.
Thank you, Councillor Lees. And finally, I invite the agent, Matthew Montague. Matthew, you've got 5 minutes to speak in favour of the application.
So, good evening. My name is Matthew Montague. I have my own architect's practice based in Longford in Derbyshire Dales. Over the past 27 years, we've amassed just under 30 design awards, the majority of which have been for conservation. We first began working on Lumsdale in 2018 when the owner, Mark Lee, contacted me and asked if we could assist in repurposing his group of buildings, which had become redundant and were no longer fit for purpose for business use. The spaces and the buildings, due to the topography of the site, their awkward relationship to each other and ongoing maintenance issues, were proving impossible to let. Whilst the buildings to the west of the road are accessible and still in commercial use, the range of buildings to the east were in need of redevelopment. Our view was that a sensitive scheme of refurbishment and redevelopment could provide a high-quality residential development which would preserve the original structures and the character of the former Bleachworks site and enhance the surroundings. Since that time, we have had a series of pre-application meetings and discussions. The scheme originally comprised 29 units, a mixture of new build and refurbishment. Over the ensuing years and following a detailed viability study, the project has matured and developed in order to retain more of the original buildings and reduce the number of additional new builds, whilst maintaining the overall viability of the development. We now propose 23 dwellings. Having carried out extensive surveys and reports, we submitted a full planning application in January 2024, and after 20 months of careful and detailed discussions between our design team and your Planning and Conservation Department, we're delighted that the scheme is now presented to this committee recommended for approval. This really is a great opportunity to ensure the future of this group of buildings and provide 23 new homes on a brownfield site. Myself and a colleague attended the committee site visit yesterday and listened to the queries raised and the comments of the councillors. I was pleased to hear that the style of our proposed new buildings, being traditional and in the form of worker cottages, was well received. We believe that this, with the removal of some of the later additional structures, will really complement the former mill buildings. The main issues raised on site were that of concerns over loss of privacy for neighbouring properties and surface water runoff and flooding in the event of heavy rainfall. With regards to privacy, the steep slope from north to south and the existing dry stone wall on the northern boundary results in only the uppermost floor of plots 1 to 6 being visible from the north. Each of these contains 2 modest bedroom windows. I checked when I got back to the office, and there's a minimum of 10.5 metres from the southern boundary of Radford Row cottages to where over the driveway to the back of our properties. So with additional screening on that boundary, which we could agree under condition, privacy will be maintained. Further to the east, on the lower part of the site, Leewood House is currently screened with Leylandi along its southern boundary. This will remain as it is and results in only the roofs of our plots 7 to 10 being visible from Leewood House. Regarding flooding, after the meeting yesterday, I contacted and interrogated our drainage engineer on flooding and flow rates. The key facts and figures were that currently, in a 1 in 100 year rainfall, the site would discharge 48 litres per second of surface water. When the new scheme is complete and the attenuation in place, during a 1 in 100 year rainfall plus 40% for global warming, the discharge will have a maximum of 22 litres per second, which is a 55% reduction in the amount of surface water coming off the site in that instance, which has to be good, a contribution to alleviating the issues. There's also mention of the water supply, which has just been mentioned across the site. Obviously, this is subject to freezing and inconsistency, and if this development goes ahead, then that will be sorted as part of the new development. In recent weeks, my client has endured break-ins to the buildings through the roof. Electric cables and conduits have been stripped and stolen, leaving high-powered live electric cables exposed. And although he's making best efforts now to make safe the building, his greatest concern is that if thieves break in again, they could be seriously injured or there may be a fatality. We really need to press on with this redevelopment in order to occupy the buildings and eliminate this danger. In summary, the creation of 11 characterful apartments and 12 new dwellings give the opportunity to create a vibrant new micro-community in Lumsdale, breathing life back into the mill buildings, ensuring their long-term future, providing much-needed housing and making great use of a brownfield site.
Thank you very much, Matthew. Yeah. So that concludes the representations. I'll invite then Edwin Vordin, who's been the case officer. Edwin.
Thank you, Chair. So, planning permission is sought to redevelop the Lumsdale Mill site, converting the mill buildings to form 11 residential apartments and the erection of 12 new build dwellings within the mill complex. So the site's located within the Lumsdale Valley. It's accessed off Lumsdale Road with the Bentley Brook running along the western side of Lumsdale Road, adjacent to the site. Lumsdale Valley is within the Lumsdale Conservation Area, and then further up Lumsdale Road from the site is the scheduled monument for the Lumsdale Mill associated water management features as well. Lumsdale Mill itself is the site of the former Farnsworth bleach works, and it's part of a group of late mill buildings purpose-built for bleaching, first established in the early 1700s. The site includes the core mill building, the Farnsworth bleach works itself, along with a range of connected and detached buildings within the complex. There's Radford's Row, a terrace row of dwellings that lies to the north of the site, and then there's Leywood House that lies to the east of the site as well, and then there's further dwellings further east of the site as well after that. In terms of the site's location, the wider context of the district, whilst it is located close to the settlement of Metalock, settlement boundary lies roughly there on my cursor, if you can see that. It's about 50 metres west of the red line boundary. it's outside of that settlement boundary and therefore lies within the open countryside. Policy S4 of the local plan sets out types of residential development that will be accepted in principle in these locations. So policy HC8 sets out that conversion of existing buildings for residential use, subject to them being appropriate conversions, acceptable in principle. So that covers the conversion of the mill building subject to their character. However, new build dwellings aren't by default accepted in principle, whilst there is some allowance for edge of settlement development in instances where we don't have a 5-year supply. Given there's technically a degree of separation between the other side of the Lumsdale Valley, it's not been considered as part of this. So there is some non-compliance with policy S4 in relation to the new build housing, which has to be considered as part of the planning balance. So the scheme's going to retain the... Oh, apologies. Let's try that again. On this... Let's have a look at that. Slides have disappeared. Seems my slides have disappeared away. Right, so I'm going to instead rely on the plans I've got access to, because I suspected this would happen. So, if I bring up a site plan with the proposed retention demolition. So if I zoom this in, so members that are on the site visit will recall that there were a range of different buildings on the site. The main sort of Farnsworth Bleachworks element, that's the element that's going to be being retained, along with the sawtooth roof red brick building that's being kept as well. The areas hatched in red are the buildings that are being demolished as part of the proposal. So this will allow a sort of passageway through the site where members may have seen on site that currently there's no way through between the buildings at present. If I bring up the site plan as proposed. So in terms of the new build housing, there's two main new build areas. So there are 6 proposed three sets of three terrace sets. So plots 1 to 6 located to the northern end of the site, just south of Redford's Row, and then in the southeast there's a block of 4 3-storey terraces. The other blocks are 3 stories as well, and then in the southern part of the site, there's a pair of semi-detached 2-storey dwellings as well. So there's 12 new build dwellings in total, and then there's 11 apartments, so 5 of which are going to be in the sawtooth red brick building, and then 6 of which will be located in the existing Farnsworth building as well. So aside from that, pedestrian links are proposed between the apartment blocks, as well as between apartment blocks 5 and plot 7 as well. So zooming in there, members will recall there's a sort of vista that will be opened up between the red brick building and the main mill building on site, and then there'll also be a pedestrian link that goes between the red brick building and the new builds in the southeast that will allow access up to the upper level of the site. So in terms of the materials, I'm going to bring up some of the visuals that have been provided as part of the application, which I'll have to open in order and go through them and comment on them as we go. So that's effectively an artist's impression of the conversion of Lumsdale Mill. So the materials will effectively remain as existing. The main introduction will be in fenestration elements. There'll also be a demolition of an element towards the front of the building. And it will allow for the introduction of larger glazed elements and the introduction of roof lights as well. This is a sample of house type 1, so there's 3 house types. This is the type that would form the 6 dwellings that would be south of Redford's Row. So, these consist of predominantly regular coarse stone, and then the further details of those stoneworks will be secured by condition. So they form a traditional mill workers' cottage appearance with some contemporary elements in terms of the fenestration and some of the materials as well. But the report sets out a range of conditions that will be used to ensure those materials are of high quality. And then they'll have a staggered building line and staggered roofscape as well. And then this is a view from the southeast corner of the site. So these are this is the set of 4 terrace units as well. So again, these are 3 stories, again with the sort of traditional materials in terms of stone and the use of fenestration as well, and the blue roof tiles too. And then you can also see further back the conversion of the red brick existing sawtooth building as well. And then this is a view of the proposed semi-detached pair that sits in the more southern part of the site. So if members recall, this is where the sort of smaller, steep access is on the southern part of the site. And then this is a view from the rear of plots 1 to 6. So each of the dwellings will have a sort of terrace way, and then a sunken garden below as well. So this sets out that the ground floor will be set below the sort of floor level, and then 2 stories after that, the topography rises up towards Radford's Row as well. So I think with that, I'll bring up the site elevations. So in terms of zooming these in here, so that's the proposed frontage of plots 1 to 6. See, it steps up in land levels across. There's a condition recommended that sets out the land levels to be secured by condition to make sure those are true to form and won't impinge on privacy. These are site sections that show the relationship between the proposed development and the relevant neighbouring property. So that's Leywood House, and then further up. And then this is the relationship here between the plots 1 to 6 and Radford's Row as well. So in terms of the relevant measurements there, it's approximately 28 metres wall to wall between the dwellings. It's a rear to rear relationship. And then as you can sort of see from the topography of the site, it slopes up. So approximately only about 5 to 5.5 metres of the total dwelling height would be above the ground floor level at the front entrance of Radford's Row. Of course, it has to be appreciated that Radford's Row only has front gardens as well, and that's been factored into the amenity assessment. So in terms of the height and the positioning of the dwellings, it's not considered that there be any sort of overbearing impact in terms of level of visual intrusion, partly because that can be just down to the separation distance, and it can also be further softened through soft landscaping schemes as well. But in terms of privacy as well, a similar approach applies just due to the separation distances. So that's the majority of the sort of proposed plans. Just talking through more of the planning elements, if I bring up the site plan again as I go through these. So in terms of things like affordable housing, the development's going to provide 30% affordable housing. It's not going to be on site. It'll be a cash provision via Section 106. That's been deemed appropriate by our housing officer in terms of the context of the site and the circumstances available. And then further contributions to be secured towards open space provision within the district as well. In terms of highways, the Higher Authority have raised no objections to the proposal. This is in terms of considering the baseline operation of the site as a mill and the existing uses available to it as well. And they've considered that based on the existing circumstances and use of the existing accesses, there wouldn't be an unacceptable impact on highway safety or a severe impact on the highway network, and that's the bar that the NPPF sets for justifying any refusal on highways grounds. They have, however, recognised that construction traffic needs to be carefully managed, so a construction management plan is recommended to be secured by condition to ensure that the construction is carried out safely and doesn't impact on highway safety and also on neighbour amenity as well. So that's the condition sets out a range of different details that we'll ask for as part of that. In terms of the drainage strategy, see if I've got this available here. The drainage strategy for the site includes 2 attenuation tanks, which are proposed in the area. So one is proposed in front of plots 1 to 3, and one is proposed in front of plots 7 to 10. And then furthermore, the site will also provide a range of porous paving as part of the construction. This is mostly going to be related further up in the northwest part of the site. So as it stands, as existing in a 1 in 100 year event, the existing surface water discharge rate from the site would be 48 litres per second. And then much of the proposed development is going to divert surface water into the attenuation system, which will limit the rate of that element to 2.9 litres a second total. So that'll apply for approximately 75% of the site. So this, as raised before, amounts to a betterment of about 55-60%, right, in that region. That relates to just the level of surface water diversion into this attenuation system, and then some portions of it will remain as existing. And then obviously the lead local authority are satisfied with the approach that's been set out. That's subject to a range of conditions, including demonstrating with any further evidence that's required that the drainage hierarchy is being complied with. So any further infiltration testing or any further investigations that are needed to pursue options for discharging into any existing watercourses need to be explored first and foremost and to the full extent before they can be happy with the combined sewer approach. But if it is a combined sewer approach, there will be a betterment compared to the existing circumstance. In terms of ecology and trees, both Derbyshire Wildlife Trust and the district's tree officer reviewed the application. Neither have raised any objections at this stage. They recommended conditions. It's acknowledged there'll be some tree removal as part of the site, but there'll also be a loss of retention as well, and the conditions set out within the report provide or require further details in terms of the protection that will be afforded to those retained trees before any works commence on site as well. So in terms of the sort of planning balance, as has been alluded to already, the National Planning Policy Framework requires us to apply a tilted balance where we can't demonstrate a 5-year housing demand supply. At the moment, our supply is 1.36, so it's significantly lower than what's required of local planning authorities at the moment. So unless there's a strong reason to refuse for any sort of protected areas or assets, or the impacts significantly and demonstrably outweigh the benefits, then planning permission should be granted. So in this case, I've afforded significant substantial weight to the provision of new housing, in 23 new houses, and it's on a brownfield site as well. This has to be balanced with the fact that it's not within a settlement boundary. This has to be, the weight afforded to that depends on the level of sustainability. So in this case, it's located in the Lumsdale Valley, so the level of sustainability is it's lower than if it was within Matlock itself, but nevertheless it still does have reasonable access to Matlock, which in itself is a first-tier settlement as well. Some harm has been identified to the character of the conservation area that it's classified as less than substantial harm. That's simply down to the level of interventions on site, particularly things like level of roof lights required to make to deliver the apartments effectively. But that's weighed against the public benefit of converting the existing mill uses and bringing them back into a viable use, as well as the wider benefit of providing housing. So in applying that balance as set out in further detail within the report, it's been considered that there's no adverse impacts that would significantly or demonstrably outweigh the benefits in this instance. So it's on that basis that planning permission's recommended to be granted.
Thank you for outlining that, Edward. I mean, members are aware that this is a very significant application and we're very anxious, obviously, to get this right. Can I just ask you then, as the case officer, in terms of plots 1 to 6, I just feel uneasy with the 3 levels, and to what extent did you feel professionally that the garages are actually essential? Because we saw on the thing the cars were parked out on the drive. I know you can say, well, it will allow then 2 cars, one in the garage and one on the drive, but it just seemed to me to be something not right within the historic context that you've got these 3 stories rather than the two, there was some nice ones that were two levels that to me blended in better.
Thank you, Chair. In terms of whether or not we deem the garage is essential, the case officer's job is primarily to assess the application as presented. So it's not something we specifically prescribed in terms of providing garages, but equally it's not something based on as presented in the assessment that was carried out. It wasn't deemed that it was necessary to remove that element of the scheme in order to make the proposal acceptable on design or amenity grounds.
Thank you for that response. Councillor Hughes, then Councillor Peacock.
Thank you, Chair. I'd like to congratulate everybody on the overall concept of this development. I think it looks as if it could be a very nice development indeed. I've got three areas that I'd like to discuss, if that's possible. In no particular order, as they say. Bins. Can you go to the top of the car park area by Radford Row? Now, as I understand it, the bins are going to be placed close to the entrance to that car parking space. And I'm a bit disappointed by that because they're not necessarily the most attractive things to have at an entrance. And entrances should be celebrated, not used for refuse, if you see what I mean. Is it absolutely essential that we have bins there, or could they be moved somewhere else?
Through you, Chair. In terms of level of bin, they have to be provided on site somewhere. In terms of the citing of it, in terms of the justification, I can't speak to that specific location aside from that the original position was located closer to the dwellings of Radford Row, so it was relocated to get them further away from the existing dwellings. They're located closer to the sort of main highway as well, just for ease of access as well for refuse vehicles. But in terms of them being the sort of best location, it's not something that's been sort of set out in detail. I'd say the Highway Authority have raised no objections to the location as set out.
No, but it's at a prominent location, and one that everybody will have to go past if they're walking in and out of the site. They're also a long way from the apartments. I assume they're for the apartments and for the houses 1 to 6.
3 Chair. Yeah. So in terms of the provisions, there's one bin collection point in that location as well, and then just moving down the site as well. So there's a further bin collection point across in the sort of southern portion of the site as well, just adjacent to plots 11 and 12. In terms of the split between those bin collection points, of which ones are allocated to which, I haven't got confirmation of which apartments get access to which ones, but one would presume it's split level between across the site effectively. So approximately half of the nearest half of the dwellings would gain access to those, or utilise the northern part of the bin storage.
Okay. They can't be placed closer to the houses then, at the bottom of the little driveway down towards the houses rather than at the top there, where it'll be a long walk from the houses and the apartments to put rubbish in. And
it's possible. I mean, it's not something we deemed essential. However, I will highlight that there's a condition that requires details of the bin storage to be provided at a later date. Part of the reason for doing that is just for confirmation about any impact on trees. So with that in mind, there's further details to be secured, and that can be considered as part of the design of them, and potentially the location to some extent as well. However, as I say, the location was amended to reflect and respond to moving them away from existing dwellings and respect the amenity distance in that regard.
Understood. I'd like to be able to secure that sort of condition in the approval if it goes that way. Second point is about screening, and the landscape conditions don't really have any objective behind them apart from biodiversity and ecology and so on. Can we add to one or other of the various landscaping conditions that the one objective is for the is to screen neighbouring properties from the development, attractive as it may be.
Through Chair, yeah, I don't see any reason why we can't add that in as a reason. Part of the reason that's not normally done by default is that the officers will refer to things like the separation distance and the height and things like that to make their assessment, and we tend to try not to rely on landscaping to deliver those. But in any case, I think providing soft landscaping to soften any sort of visual intrusion and visual change in the relationship between the site and existing dwellings can only be beneficial. So that can be thrown in as part of the reason and context for why that condition's been secured. Absolutely.
Okay, thank you. Now, the third point is about the drainage hierarchy. And there are two conditions. I think it's 6 and 7 associated with drainage. Is it 6 and 7? Yes, 6 is about a management and maintenance plan for surface water drainage on the site in accordance with a number of documents. And then the second one is about the 7th is about the hierarchy, the drainage hierarchy. And I'm a bit confused about whether the first of those takes priority and whether it implies that there would be surface. The primary method of delivering surface water drainage will be through the combined sewer, whereas I think the hierarchy would suggest it should go into Bentley Brook. And your correspondence with Peter and I suggests that you understand what our concern, but it's not clear in the conditions that the hierarchy takes precedent over the management and maintenance condition at this stage. Is it possible to put something in that would secure that precedence of the drainage hierarchy over the other?
Through you, Chair. So I understand the concern in that, yeah, Condition 7 effectively requires further investigations to be done to either sort of confirm or deny whether the combined sewer approach is appropriate, because indeed there's matters such as infiltration testing, and members will have noted the existing outfalls on site. And understand, I think, the LFA have said it's perfectly reasonable to ask that those are investigated to see if it's feasible to use those, because in line with the hierarchy, infiltration should be explored first and foremost, and then if there's existing outfalls or potential to make a new one into the Bentley Brook, that should be explored as well. And then it's only after those have been ruled out that the combined sewer approach can be pursued. And indeed, it's what Severn Trent Water will also expect before approving a connection too. So, yes, I mean, we can have a conversation, I think, about in terms of how we can incorporate or highlight that the exercise done in Condition 7 needs to be incorporated into any sort of detailed drainage and management plan. Yeah. In practice, those would be done part and parcel. They would do those elements of testing and investigations, and then submit the maintenance or management maintenance plan off the back of that. But it's certainly something we can look at in terms of setting out the wording and demonstrating that for the management maintenance plan, we would expect it to have regard to the investigations they carry out as part of Condition 7, for example.
Okay, thank you. And can I just fill the fourth? I know we already have 3 normally. The pipe that goes across the site. There was a case in our ward a year or so ago where there was a pipe going across a development site that got damaged by the developer, and it turned out that, I mean, in law, the user of the water that's going through that pipe turned out to have to pay for the pipe to be redirected. Now, it's not clear here whether that will be the case or not. The work may be done during the development period, but is it going to be done gratis as far as the user of that water is concerned?
Through you, Chair. So it would effectively be a legal matter between the owner of it and then the developer as well. It's something they would still they'd have to be aware of and have to carry out. And if a diversion is necessary, then that has to be agreed with the lead local authority as well. I believe the lead local authority have set out in previous sets of comments a series of informatives and things like that highlights the requirement and obligation to carry out those exercises, so that can be incorporated into a decision notice just to make the developer aware of that. Even though I'm aware that based on the site visits and correspondence today that they should be aware of that already.
Okay, thank you.
David, Councillor Peacock.
Two short questions, hopefully. Just out of interest, really. It's outside the settlement boundary, but we're going to build 22 dwellings. At what point does that become a new settlement?
Through you, Chair, I suspect I'd have to defer to planning policy colleagues in terms of whether or not it would meet the definition of a settlement as part of their local plan review. In my professional opinion, I don't believe that it would constitute a settlement off the back of it. But in any case, as I say, it's not something that's been sort of considered as part of the assessment of the application in this instance and the sort of consequences of it. But for the record anyway, planning policy will be kept up to date with the planning permissions that are granted and the type of schemes that are coming forward outside of settlement boundaries, and whether or not that impacts on their existing exercises for identifying the settlement hierarchies and confirming what the makeup of our district is.
I mean, I'm just interested, partly because I agree with Councillor Hughes. I think this is a really nice design. I like the three-storey houses. I think there's lots of three-storey worker houses in Derbyshire Dales. But my other question was about these attenuation tanks. I don't suppose you might not be able to do this easily. Don't worry if you can't. I don't suppose you can. Is there a map that shows how they fit into the? And does that affect? Is that part of the reason why some of these trees are being cut down, for example? Is what I want to know.
If you bear with me, Chair, I can bring up the drainage strategy, but I'll need to find it because I suspect it's not within the pack that I've got. So if you bear with me a second, I can get the drainage strategy planner, which shows where the location of the attenuation tanks are, if that would be useful.
Yeah, so a related question really was, is it some of the speakers referred to the idea of the developer speaking to the local residents in order to perhaps change some of their plans regarding the existing trees, especially. Is that normal? Is that possible?
Through you, Chair, I'd say it is in terms of how the developer wishes to proceed in terms of working with neighbours to deliver something that works as best as possible for everyone. I mean, I would welcome and encourage the developer to do so. I can only see that benefiting both parties in that instance. I'm not certain that is something we can prescribe or require by means of planning condition. We can only pursue that it's review the details that have been submitted in terms of the sort of quality and also in the context of the reason why we asked for the condition, just to confirm that they meet or that they fulfilled the purpose that we've sought those details for. So we can review and choose whether or not to accept any landscaping scheme or things like that have been submitted. But as far as I'm aware, I don't believe we could prescribe any level of sort of public consultation for a particular condition. But as I say, in any case, as a matter of record, I'd always encourage developers to engage with neighbours and work on those schemes, because a lot can be potentially resolved through conditions at that point.
Incidentally, we found a thing, and I think interesting.
Councillor Lees.
Thank you, Chair. Very engrossed in this meeting. I think we forgot to extend the time of the... meeting.
Will you move that?
I will.
Yeah,
I'll
seconded it. I think. What's the thing?
Yeah, we need to take a vote.
An hour?
Okay.
Yeah, there's nothing lost. Let's extend it by an hour.
Thank
Yeah.
you.
All those in favour, please show. That's unanimous. Thank you. Thank you. Councillor Lees, your...
My question is, yesterday when we were on site, he was going to get us a height in relation to the existing building and the one off Radford's Road to the new building. There's one question. Have we got any height on that? Missed it.
Through you, Chair, I can bring the relevant elevation, the sort of site elevation plan up, if I find it. And then I can try and be quick on the draw in terms of
talking about 4 metres higher. Is that the case?
Yeah, so I've measured it specifically. So it's in terms of comparing it with the existing warehouse that's adjacent to Radford's Road that you'll have seen on site. It's 4.4 metres high. So actually, I'll bring up a more useful diagram, which will set out the difference between it. So it will highlight the existing warehouse, and then it will highlight the height of the dwellings as well. So I've got that up there, and it looks like in advance I've actually annotated the measurements, so even better. So this is it. Apologies if the markup is a bit difficult to read or understand, but so the red dotted line indicates the existing sort of ground levels and where the existing building is. So that was the warehouse that you saw on site adjacent to Radford's Row. So yeah, it's approximately 4.4 metres in height raised up from that in terms of the new dwellings. But sort of as you can see, the topography means that that a portion of the new dwelling height will be sunken when compared to the road or the track access to Radford's Row as well.
Thank you. Another little question. I don't think it's not a question at all. Really, it's a comment. I think with the other mill buildings, more of a design issue. We've been asking for chimneys on other properties, but I don't think these look right on these properties. But that's just my comment. Thank you.
Councillor Murphy.
Thanks, Chairman. My questions are, well, one of my questions is about the contributions, and obviously there's calculations and whatever. I was interested to know the applicants are very comfortable with that amount of money that we're asking for. It's going to be a very expensive development to develop, obviously, and nationally, if you read in the newspapers and whatever and articles, there seems to be many cases whereby developers come back after being granted planning permission and talk about viability and whatever. Are we comfortable that the developer is going to be able to afford, with this type of a development, that sort of contribution?
Through you, Chair. So, because from the outset, in terms of my involvement with the case, that there's never been any indication that the contributions were not going to be met. The level of viability and scrutinising any sort of documents, those in terms of that, it's not something that was done in depth on the basis that all of the contributions were going to be met in any case. So we would be, of course, operating on under the assumption and indeed the permission would be granted on the basis that those obligations would be and contributions would be secured. It would have to be re-referred if the decision were otherwise, effectively, if it turned out that the contributions couldn't actually be met. Like I say, I haven't been presented with a case that it would make the development unviable, and if I had, then it would need to undergo the relevant scrutiny of independent consultants to set that out, and then that'd have to be balanced with setting out the benefits again in that sense. But in this instance, that's not something that's been sought, so it's policy compliant in terms of the level of obligations that it's meeting.
Okay. Can I have another question?
Yes, absolutely.
Yeah, right. Okay. Noted when we were driving up to the site and then probably more so when we were leaving it, how sort of constricted those roads around the site are. I'm just wondering, and Councillor Burford will understand this, it would be useful if we could get highways maybe with the consideration that at certain times of year there's a lot of parked cars on some of those narrow roads. Could we talk to highways about implementing some double yellow lines? Because I could imagine it'd be a nightmare for the people who already live there, and then all the new people moving in, if they have to sort of, you know, have a slalom trying to get in there. And of course, obviously, there's access for emergency vehicles and any other major vehicles. And I know we don't have the power, but is it something we should put in train now? Because, as Councillor Burford knows, it takes forever to get highways to do anything. Be interested in your opinion
And
on
can
that.
those concerns be conveyed to the county, Edward?
Through your chairs, so I think yes, but most likely outside of the confines of planning committee. I think absolutely. I think that for the district council as a whole can make. I think members could put forward a motion, but most likely I'd say that'd be separate to consideration of this item, or indeed the planning committee as a whole, and then that can be something for highways to explore if they choose to or see fit, and carry out any studies they deem to be necessary.
So maybe the local county councillor can put that in train. Thank you, Ed.
So at the moment, in terms of speakers, we've got Councillor Sue Burfoot, Councillor Slack, and then Councillor Buttle.
Thank you, Chair. I've certainly made a note of that.
You're going to be asked.
Yeah. I've got sort of two questions. I think the easy one is it at all possible, if we're minded to approve this application, that we could condition that the conversion to the existing buildings are completed before we have the new build? Is that possible? Because I think, we've seen before where we've been left with, we've got new build that are easy to sell and we get the rest just left.
Through your chair. So it is something that could be conditioned in terms of setting out the phasing. The impacts and consequences of requiring that is not something that's been considered as part of the assessment, but that is something that could be done if the members were satisfied that was necessary in terms of satisfying the relevant 6 tests for planning conditions. So it would have to be necessary to make the application acceptable on all the relevant grounds.
Thank you. Oh, yeah.
Any further?
Through you, just one further comment on that. What we're not in full knowledge of is the degree to which that requirement might affect the viability of the scheme. The phasing is often very important to the viability and deliverability of a particular scheme. So whilst I can completely understand the concern, in order to meet the test of the condition being reasonable, it might be appropriate for a phasing plan to be submitted, and then if there is a viability issue, and there may not be at all, then that point can be made by the applicant when that condition is discharged, rather than specifically saying at this stage it must be occupied prior to the new build being built. It's a nuance, but I think in order to meet the tests of being reasonable, I would suggest it was framed in that way.
Thank you. I do understand that. I probably didn't mean occupied, just built.
Yeah.
Because sometimes, obviously, things get built, they don't get sold straight away. I wonder whether, Edward, could you have a look at, on page 67, condition 20? I don't know whether it's me, but members probably know that I have got a thing about brickwork. And it says, before works begin on any existing external surface brickwork, details of the proposed brickwork should be submitted, and the rest of it. What exactly is that referring to? I do notice, and I'm afraid I didn't read, I haven't read the full submission from Tansley Parish Council, but they are saying housing material is unsympathetic to the surroundings. Do you know what they're saying there?
Through you, Chair. So just in terms of the condition wording, part of the reason, so this relates predominantly, as I understand it, to the existing red brick building. There are other conditions within here that secure external materials for the wider site. This part in part allows us to have. It gives some more flexibility, both to the developer and also to the local planning authority in terms of separating out those elements. But also, it sets out that we're asking for specific details on particular buildings, because different buildings have different materials and different levels of detail required. So the brickwork in particular is something we want to make sure it was done appropriately for the retained building, and then similarly the stonework for the existing mill building as well. In terms of Tansley Parish Council's comments, I suspect if I find the date of response that's set against that, I anticipate that it's some time ago. So the original design that came in was quite significantly different in terms of the materiality that was set forward. It was a lot more contemporary in nature. So there was a lot of work that was done in terms of raising heritage concerns, both Historic England and our Conservation Officer. So amendments came in to provide a more traditional approach to the material palette. So it may well be the case that Tansley Parish Council comments refer to the previous ones, but in any case, if they refer to the current ones, the Conservation Officer is happy, subject to further details, just making sure that they are high quality sources at the condition stage.
Councillor Slack.
Thank you, Chair. Congratulations, Edward. I think the contributions are fantastic, so that's good. My questions are, first of all, one question is the modern world. Will there be EV chargers all around the site for electric vehicles?
Through you, Chair, that's secured through building regulations these days, and I can't speak to the nature of the provision, but building regulations set out the necessary requirements for new dwellings and the level of provision for EVCPs, for example.
Yeah, thank you. My next question is, they're very historic buildings. A lot of these go back to the 17th and long way back, 17th, 18th century. Will the preservation of the buildings, when the buildings are repaired, they will have to be properly done with heritage. That'll cost a lot more money, won't it, to repair these old buildings? Has that been taken into account?
Through you, Chair, I hope so. From the developer's perspective, in terms of the level of the standards that would be expected in terms of restoring them, I'm sure that in terms of a developer will go in. They'll be fully conscious, I trust, in terms of the challenges that will be associated with converting existing buildings on site. Materiality will have to be sort of carefully considered as part of that, and we would expect it to be, as I say, of an appropriately high level of quality to match the sort of calibre that we'd expect in and also the Lumsdale conservation area. Yeah.
And my third question is similar to Sue's. Where will you start? Will the new build be built first so it generates capital for the rest of the... Because the new build will generate more money, won't it, than the alterations to the listed buildings?
I can't speak to the phasing that's set out at present. However, if members are minded, they can include a condition that sets out or requires a phasing plan to be submitted, which would clarify how it would be delivered on site, the ordering in which it would be built out. If members felt that was necessary, so that would clarify at that stage how where the conversions would take place and when the new builds would take place.
Yeah, thank you.
Thank you, Councillor Syke. Neil.
Thank you, David. I have to laugh, really. I have 14 questions here, and they have all been asked. Yeah, like, all I've got left is at what point will we be asking for the Section 106 monies to be delivered?
Edward, can you respond to that, please?
Through you, Chair. So normally the level of contributions is requested either sort of pre-commencement or there's a set trigger or a set level of occupation that's required in advance. The actual trigger that's set out, I can't confirm at the time, but it would usually say it would be either pre-commencement or given a set level of occupation of existing dwellings. But as it stands, I'd be minded to say that it would be or effectively an on-commencement figure to be, or a sum to be provided once construction had started or by construction starting.
I'm afraid I've got a really unfair question as well. Due to the tilted balance and the fact that we are very, very likely to approve, what compromises do you feel that you might have made that you would not have made otherwise? And I do accept that is a really unfair question.
So, through you, Chair. So, in terms of, I mean, just to set the wider context, the sort of core fundamental legislation context for a planning officer's job and indeed a local planning authority's job is to assess any application that comes in against the development plan. So that's the local plan and then any other plans that go into that, neighbourhood plans, such like that. You'd assess it against that and then determine it on that basis unless there were material considerations that indicated that you shouldn't do that. So if it was purely against the development plan on its own, before anything else, there would be reasons to refuse it on the basis that it's technically in the countryside and there was some level of harm based on conservation. However, the National Planning Policy Framework is a material consideration in itself because it's the national policy that sets out how all local plans should be based and how all decisions should be made as well. So that plays a huge role in setting out how officers and councils have to make their decisions. And that says that things like heritage have to be balanced out with public benefits, and that particularly when it comes to housing developments, effectively the benefits have to be weighed up. And if you're not performing on housing supply, then you have to. There is an overarching presumption of sustainable development, and as I say, that tilts in favour when you're not performing on housing. So, yeah, as I say, that's the sort of layering that's undertaken. Is you look at the development plan first, and then you consider whether there's any material reasons why you shouldn't determine it in accordance with the development plan. That applies in any case, even without the tilted balance.
A final question.
I do have one final one, which is to do with the access, which is constrained. And I'm wondering if there was any particular thoughts as to getting a 22-ton Serco lorry up there and whether or not that's a relevant thing, or do we, as the district council, do we just sort of send the largest lorry we can fit? And is that part of considering the size of the things and the narrowness of the road and how close it is to the river and whether or not it has been properly maintained over the years? Are we confident that we will be able to provide services to this development in the future?
Through you, Chair, the Hire Authority haven't given me any reason to doubt our ability to be able to facilitate bin collections, things like that, or indeed access for emergency vehicles for this site. In terms of how it's considered, I mean, it's based in part off dealing with existing circumstances. Indeed, there's other dwellings in this area, so it's utilising existing accesses in that regard. And indeed, the site itself does technically have a lawful use as a commercial building. Officially speaking, it could be brought into use today. Of course, there's the report sets out there's reasons why it's not being, and we're talking about its conversion, but technically it could be brought fully back into operation today for commercial purposes. So in that sense, we're dealing with that baseline of the existing circumstances. and whether, when compared to that, we can deliver the same level of services for these. And as I say, there's not been any indication from the relevant authorities that that wouldn't be the case.
Thank you very much.
Any further questions? No. Debate and hopefully a motion. One of the problems sitting up here is we're isolated from those suites. Is there any chance? Can I avail? Nigel, is there any chance of? Thank you. Wonderful. Nigel, you're on the Christmas card list. You are now.
Where's your little tin?
Yeah.
I'll leave them with you.
Thank you.
Do them all.
Thank you. So,
Who are they?
at this point, seriously, we've had a lot of good questions asked. We took great care yesterday at the site visit, and we met and heard from the ward member and took on board comments that you were conveying to us, Joe. So, we've got an officer recommendation of approval. So it's down to you members now. Is someone prepared to approve the application or wish to move refusal? Councillor Hughes.
Yes, I'd like to move that we approve this recommendation, but with 2 changes to conditions. The first change is to swap conditions 6 and 7, so that the drainage hierarchy is placed before the other drainage, the design and management and maintenance condition. That seems to be the appropriate to do that in terms of the ordering of the conditions, but also add to the new condition 7, which is existing condition 7, subject to the detailed assessment specified in condition 6, no development will take place, so that it's clear that the drainage hierarchy takes precedent over the documents that are specified in that list in condition 6, that would now be condition 7.
Councillor Dobbs, are you prepared to second the?
I've got one more.
Sorry,
one more condition. Then I'd like to just add to the landscape and biodiversity condition 5, B, and it says B says aims and objectives of the management in line with desired habitat conditions detailed in the metric. And then I want to add, and a requirement for screening of neighbouring properties, and then just add as a reason to maintain the privacy of site occupants and neighbours.
Does that find a seconder? Councillor Dobbs, thank you.
Yeah, happy to second. And if Edward could or Chris could just confirm that what we saw on the site visit looked like surface water discharge into Bentley Brook, which is slightly at odds with what current recommendation 6, part B, this revision PO3 to the Benjamin Allen Consulting Engineers, that actually suggests that all rainwater is currently going into the combined sewer, whereas our observations suggest that it possibly might not. And if that just could be clarified, do we need to say any more in that condition, or is that covered by what we've got?
Through you, Chair, that should be covered through the drainage hierarchy condition, insofar as the LFA have gotten onto this, that, you know, the awareness, members and the legal authority are aware that these outfalls are present, and it's not been confirmed at this stage exactly how they link up, but we would expect, as part of the wider investigation, that the source of those is found out. As it stands, there's some level of speculation as to what those serve and when they were built and things like that. But we would expect the developer explore options for those to be used and in order for us to discharge the drainage hierarchy condition.
Thank you. I would just add, in response to Councillor Linthwaite's request that we need to improve the situation. Of course, this will offer betterment. This is exactly what Severn Trent wants to happen, and this is a mechanism where we can get the surface water out of combined sewers and allow them to have greater foul water capacity.
So Chris would like us to clarify the reasons.
Yes, thank you, Chair. It was simply that just so that officers get this right, if the committee is minded to grant consent, the revised wording to condition 7, I've noted that there was something that words were to be added to the end, subject to the detailed specification of condition 6. No development will take place. After they've obviously so they've been swapped around.
Yeah, and then it's the new condition 6 and the new condition 7 that I'm talking about here.
Right, okay.
Yeah.
I think that makes more sense.
Yes.
Okay, thank you.
Should
All
do.
right, thanks for the clarification.
Councillor Peacock, did you wish to say anything about the motion?
No, I was offering to second it, but
Thank you.
Councillor Dobbs got there first.
Yeah. Can we now just simply put that to the vote, please, as outlined by Councillor Hughes? All those in favour, please show. And that does appear to be unanimous. Thank you, members. We move on then to our final application tonight for determination. Can I thank the applicants for their patience? It's been a long wait for you, but we will now determine resurfacing and widening of driveway, which we looked at yesterday. New treatment plant to replace septic tank. Now, thank you. Before we get to the two speakers, members should have before them a letter from the clerk to Bradley Parish Council. As we've done with other pieces of correspondence, can you just take care for a few moments and read what has been presented to us? So I ask him first, and then the applicant. Thanks. Okay, can we proceed then to listen to George Dutton, Chair of Bradley Parish Council?
He's got 3 minutes, Chair.
And Mr Dutton, you've got 3 minutes to convey.
Good evening, Mr Chairman, members of the committee. I'm George Dutton, I'm the Chairman of Bradley Parish Council. The Parish Council looked at this application, and although we thoroughly appreciate the need of the owners of the property to widen the entrance, we feel that the plans submitted by the applicant are not acceptable for the following regions. The access, even though it's got prescriptive rights for the current size, it's exceedingly close to the old Pinfold Farm dairy cow shed. We know it's an old building, it's not listed, but I, in 1957,
visited the farm, and the farmer there, Tom Brown, the son-in-law of the Gregory family who had owned it for 3 generations before then, he was hand milking, so I know the facts of that building, and it goes back generations. So we feel as councils we have a duty of care to look after the old buildings. There aren't many like that one left in the parish. In fact, there's only probably 2 more. And extending the width of the entrance as it stands would allow traffic that could be much larger. Now, I know the applicants have got a Land Rover and horse box, but if you think of horse transport going forward, even if you go with a small 2-axle 4-wheel drive vehicle, or motorised horse box, they are 8.5 metres long, they're 2.4 metres wide. Now, I don't know whether on the highways survey and analysis, they've actually plotted that size of vehicle getting into the site, but we have, and it's so close to the old building that you couldn't walk, pedestrian couldn't walk between the near side front. This is approaching from the east side, from the Pinfold and down Pinfold Lane. So therefore we feel it's so close to the building as to be a danger. If in winter you were to have snow and ice, then there's a possibility of hitting this old building. The options, we feel, there's an opportunity to move the access further away from the building. That way the applicant gets what they require, which is a better access for their current needs, but it also safeguards this old building, which is part of the heritage of Bradley Parish. Now we've a duty of care to speak up if we think there's something that's going to put our old buildings in danger, and we do feel this is a real actual fact. I'd like to know if the highways have done a vehicle, in position of that, trying to get in. You'll see what I'm saying is absolute truth. So whilst we admit that you can get in easily with an articulating vehicle, that's fine, but you can't get in with the bigger vehicles, which are right for up to 7.5 tonnes.
Thank you, Mr. Dutton.
Thank you.
Yeah. So I'll invite the applicant, Kim Ford, and Kim, you've got 5 minutes as applicant.
Good evening, everybody, and thank you for giving me the opportunity to speak. I'd just like to raise a few points regarding our planning permission. To widen the drive and resurface, I know there has been concerns about the old building, but naturally to widen it we would be further away from the building, and if we were to move it further away, I think it would propose a danger on the turn, because the drive would be more of a bend, and it would also mean removing more of the conifers. I know yesterday in the site meeting I pointed out the few conifers that would be removed. If it was widened even more or moved down, we would be moving more trees, which we don't think is necessary, and also removing more soil, which I know that was mentioned yesterday on the site visit, that we're not having to move much at all. The other point I wanted to make was the septic tank. It has been mentioned that we have got a legal dispute going with our neighbour, but we are upgrading, hopefully, the tank to a new treatment plant, and it will be going down to the brook following advice from Alex Taylor from the Environmental Health, and working with building regs as well. So I just wanted to make that known as well, because I know yesterday on the site visit we pointed out the septic tank, but we didn't clarify where it was going. It's using existing pipework, but we'll be going down to the brook. So I just wanted to make those points known to you. Thank you very much.
Thank you, Kim.
Thank you.
Okay, thank you. Oh, right. I think, Rosie, you're taking this application, aren't you?
Thank you, Chair. So this application is for the resurfacing and widening of an existing driveway and for a new treatment plant to replace an existing septic tank. So we visited the site yesterday. So here's a plan here that shows how they wish to widen the driveway, and as the applicant just mentioned now, that will involve the removal of 4 of the conifer trees that form this large hedge in front of the property. So there'll be some slight regrading of the existing access as well as part of these works. So that's a photo that you saw yesterday, and this was the barn the parish council mentioned, and obviously that's sort of an existing situation that the access as it is close to that building. So they're looking to extend it by removing those 4 conifer trees there. As you know, we've had objections from the parish council, and they've just spoken just now. In terms of other consultees, we did get some comments back from the highways department. They're happy with it on a highway safety view, because that's probably the main consideration that we have here with the application that's in front of us today. And they've asked for a condition to be imposed, condition number 3, which is on page 79 of your report, that no part of the development hereby permitted shall be brought into use until the access driveway turning area are constructed, and provision to prevent the unregulated discharge of surface water to the public highway. So that would be putting in some drainage sort of system there. The applicant also mentioned that there's a replacement sewage treatment plant that's going in the same area as the existing sewage treatment plant there. So we did actually go and see that on site yesterday. So this has a recommendation for approval for the 3 conditions outlined in the report.
Any questions from members? Councillor Lees.
Thank you, Chair. In planning terms, regarding the concerns, would it be possible, or is it within our remit to say, move it at least another metre away from that building, and give them take another conifer out? Is that within the remit of this committee or not?
We've got the plan that we've got in front of us today that doesn't actually show that. Obviously that would be an alternative option, but we don't have that to consider in front of us today.
But could we impose that as a condition, that it's moved a metre away from the building?
I think because you'd normally approve the permission in relation to a plan that you've seen, that's sort of the fundamental sort of part of the proposal. It's not something additional like landscaping where you'd ask for a supplementary plan.
Any further questions? Councillor Dobbs.
Sorry. Just to check, notes to applicant bullet point 1, first bullet point presumably was an error.
Yes, I'd say that. We normally have a standard informative about whether it was positively determined or negatively determined, and that seems to be the negative one, so apologies for that.
So, members, you've got a recommendation of approval before you. Are members minded to approve this application? We took care on the site visit. Councillor Slack.
Yeah, I'll move it, Chair.
Does that find a seconder?
I'll second it.
Councillor Burfoot. Does anyone wish to speak to the proposition? It's been moved and seconded that we grant approval. All those in favour, please show. Those against? Abstentions? 3 abstentions. Thank you. So we actually move on now to appeals, and on moving from the chair that we note these, I want to speak on one of the later ones. So does anyone wish to speak on the one report preceding the cost decision with Old Hackney Lane at Matlock? Councillor Hughes.
Chair, I'd like to signal my disappointment in this decision. There's a green, the Matlock Bank is built over in lots of places. The fields that this will be built, this development will take place on is a natural divide between developments along the bank, and will reduce the amount of greenery in that area, and it will be detrimental to the attractiveness of that part of Matlock Bank, and it's very disappointing. It'll be possible to see it right from the other side, from Bonsall Moor, and that in its own right is disappointing.
I felt it was important for me to convey some of the comments from the inspector over costs, and I thought they were quite significant. Members of planning committees are not bound to accept the recommendation of their officers, and the ability of such a committee to reach its own view is an established part of the planning system. Such behaviour becomes unreasonable where the reasons for the decision of the committee are unclear or unsubstantiated. In this instance, the concerns were clearly stated and adequately reasoned within the council's evidence. Even though I ultimately allowed the appeal, like the council, I found that the proposal would result in a degree of harm to the character and appearance of the area and local landscape. This indicates that the council's position in this regard was not unreasonable. And I won't bore you with others because I'd like to have read it to you, but having established that the council's behaviour was not unreasonable, it also follows that the delay incurred is also not unreasonable, nor was the expense incurred through the preparation of appeal evidence avoidable. It is also noticeable that the council appears to have cooperated, so thanks to our officers, during the appeal process in agreeing common ground, narrowing areas of disagreement and progressing the planning obligation with the required timetable. Therefore, unreasonable behaviour resulting in unnecessary or wasted expense has not occurred, and an award of costs is not warranted. David.
Yeah, can I come back on another point, actually, and that is there were two developments side by side along Hackney, proposed along Hackney Lane, and the developers wouldn't agree on providing links between, or to combine the one with the other, and that is it's certainly contrary to what we're putting into the revised local plan. I'm not sure whether it's in the current local plan or not, where we have we do not want isolated settlements. We want settlement, and we want developments to be joined together so that they form a coherent whole, so that people can walk around and a community can be created, rather than silos of people living in separate little enclaves, as will occur on this particular landscape.
Thank you for those comments, David. Are there any further comments? If not, I do, as chair tonight, thank you for your patience, for all your contributions, and I formally close the meeting. Thank you.